All right, welcome everybody. This is a meeting of the Town of Rutland Zoning Board of Appeals for August 3rd, 2022. Here we have Rick Surratt, member Rick Surratt online, and Paul Corain is online. Also have alternate member Butch Nadeau. Also have member Jacob Morris and Vice Chair Bob Paulson. My name is Chris Senecal, I'm the chair. Tamika Murphy is the secretary, keeping everything together here, and there's been a lot here lately. First up on the agenda for this evening is the meeting minutes from July 6th, but we'll wait for Paul, who's en route to the meeting, to be here in person to do that, so we'll postpone that till after. Next up on the agenda was a continuance of the public hearing for the Blue Skies Tower LLC for seeking a cell tower permit and an application for a special permit for a cell tower. We're going to postpone that as well. And one of the latter items due to Paul being en route under new business is a situation with Dunkin' Donuts, a review of a past Board of Appeals decision for the Dunkin' Donuts at 255 Main Street. So, with that being said, there was an email that we received, and who did that come from exactly? From the Historical Commission, and that went to Gary Kelleher?
Yes. And the building inspector.
And the building inspector. Okay, all right. So, I guess it's the situation where, back in 2002, what I understand from what I read, when there was a ZBA hearing on that matter, and there was an order of conditions placed on that structure to have wood siding and not a vinyl or an alternative material siding to keep with the historical features of the Center District of Rutland. And was it back at that time they didn't meet it, or was it just now that they didn't meet that criteria?
Well, it's hard to say.
Nobody really knows what they put on back then.
It was
Is that what you said?
supposed to have been.
Supposed to have been.
Correct.
Okay. But right now, it's not vinyl siding, and they just remodeled the place. Is that the situation?
Correct.
It is vinyl.
It is vinyl.
It is vinyl. I'm sorry. It is vinyl right now. It's not wood that it was supposed to be back in 2002
That's the original building.
as an order of condition. Okay. Whew. All right. So,
Save the
Gary,
comments.
does anybody have any information on this that can expound upon anything here, or?
We'll try, Mr. Senator.
Yeah.
Thank you. Yes, Gary Kelleher, Town Administrator, Town of Rutland. This goes back to actually before '02 to 98, 99 timeframe when the building was first constructed. It did call, everything I've looked for, every file I've looked through does call for wood clapboards. What they did put up initially was a composite of wood and cement. The issue with this is, as I'm sure you all know, and certainly Mr. Williams knows, that it was signed off and accepted by all those involved in the building department.
So back when they originally built it, it was a
Originally.
combination of wood and concrete, cement,
That's correct,
fiberboard?
that's correct.
Okay.
And that's only for longevity of the product, obviously.
Sure.
It doesn't get weather beaten as a straight wood
maintenance
would.
issues and
You don't have to
everything,
repaint it as often, so on and so forth. But then they did some remodeling. Obviously, they're at the stage where they are today. It is not a wood clapboard, nor does the siding have any composite of wood in it. However, again, everything was signed off by all of inspections, and the COs were issued in both instances. So I've actually talked to Dick Williams many times about this, and this has come up many times in the town, in the course of business, to see what we should do, if anything, where we stand. So I am here to actually ask the Zoning Board of Appeals to approve this as is, if that's the next step to be taken, Chris, and move forward and put this to rest. And certainly, Dick is here. I've talked to Dick about it many times. He's the one that said that I should come to ZBA to make this request, just to put it to rest. And we can't very well, I don't think, it wouldn't be feasible to have Dunkin' Donuts. Errors were made. I'll give you that, errors were made. But to have them come in and strip that building and put a new wood clapboard on it, if you will, which would require constant maintenance. As you know, everybody knows what wood is, and as opposed to vinyl. our own town hall. I don't know if you remember, I'm sure you remember, Chris, I'm sure Dick remembers that I actually had that changed from wood to vinyl, going back 10 or 12 years. And there wasn't any really big controversy about it at the time, because it also came with insulation.
Did the
So,
historical
it's a different building.
foundation look at that at that time? Was that a?
The historical
reviewed?
did not get really involved in it at all. It was just, it was prior to having a town administrator. So it was just buildings,
Yeah,
and
just doing
myself.
your maintenance, do what you're supposed to do, right? Yeah.
Right, right. So at that time, as you know, I was a director at DPW, so
Yeah, yeah.
I put it out to bid and got the work done.
Got the work done, sure.
So just, just trying to put this one down, and hopefully get everyone to accept it as it is. It looks great, and we all know that.
Does look really nice, I gotta be honest,
Yeah.
I couldn't tell it wasn't wood just driving by out on
I
Main
know,
Street, to be honest with you.
lifelong now,
Even
the X
inside.
Series lifelong product, so just asking for your help and support through this. I don't know, Dick.
All right, well, we'll do all we can do here to straighten this thing out. Dick, are you here to represent the Historical Society, or just yourself, or?
Just myself,
Okay.
from remembering way back when. And
Sure.
I just feel that to the zoning board of appeals back then, it's only right that you follow what they had gone through all the hassle to do. And to change it, you either go through town council and spend a lot of money, or just go through you people. And I feel that you are the better avenue of this to just make the change, period. And I feel that that's the better way of doing it.
I'm sure you mentioned this, the letter that you got from Historic,
Yeah.
and do you have that, Mr. Chairman?
I do, Gary. Is there anybody from the Historical Society? Ma'am, yeah?
Historical Commission, Jen Ledger.
All right, Jen,
Yes,
welcome.
I just I guess, represent the commission's perspective
Yeah.
on the issue. We didn't have a commission for a little while. We're just recently starting to get back into everything, so we're trying to, like we've been tasked with, preserve the historical integrity of the town as we can, and we were hoping the inspector would support the original court ruling to maintain that original wood clapboard just for that purpose. So I understand where you're coming from. The work has been done, it's been signed off on. If that is the case and what the board decides today, I think the bigger question that we would have as a commission is, moving forward, how do we prevent this from happening elsewhere? So if there's already, rulings out there, how do we make sure that those are being followed and we don't get back to this situation again, where we feel that there seems to be a record of do first, ask forgiveness later, and not necessarily follow what we're supposed to be doing. So I think that's our bigger question at this point is if
Well, so I think, yeah, I mean, just at first blush, particularly with this particular thing, when you have an order of conditions, that's kind of separate from a historical review board, something to get a permit, there has to be a historical review in a zone particular area. So those are kind of two separate issues, Jen, just from a management and how you deal with it from a town-wide perspective. Orders of conditions is usually somebody, the building inspector, or, maybe a civil engineer, if it's all site work related types, order of conditions, that they review this before certificate of occupancies can be approved and allowed. And that's in the order of conditions in a site plan review. So that's how that's usually normally handled. And it doesn't sound like that was handled well back 22 years ago. God.
And I agree with that statement 100%, and I agree 100% with what
Is
you're
there
saying.
is there a historical district that's defined in town, or is it just kind of
we
quasi?
do not have a historic district.
Okay.
It's not something that we have in the town. No.
So it's just a matter of right now and or back then, they would just represent and give their opinions based on projects in the town center area, and then they would, either the zoning boards or planning boards would either take that into consideration or would not, and then it sounds like they just took that into an order of condition at that time. But it wasn't like a mandate or anything like that you had to go through a review board. Like some towns, like for instance Fenway Park, that is a historical building, and it takes a long time to get a permit in Fenway Park. So believe it or not, in the city of Boston. So certain areas you just can't. You got to go through those boards, and it's part of their application process. Yeah,
As it should be done, and
Yeah.
I'm gonna reference it, and certainly what she states is correct in the letter from Peter. It does say on page 2, paragraph 3, that obviously in the future, they wanna be conferred upon with future building proposals relating to adjacent properties of 255 Main. And I understand there was a mistake, I really do, and this, on behalf of her and the historic, should certainly not be precedent setting. So this has to be followed more closely with an inspections department or an RE, if that's the case,
Yeah.
but especially in the downtown area, and especially when there was an order of conditions that did state wood clapboard.
Yeah. That's really,
That's really the only way to do it though, right? Because they're concerned about ensuring that it doesn't happen again, and in answer to her question, I think that is through your department that.
Right.
That would, yeah. I mean, is there anything else that we could do to?
yeah, the building inspector's not here tonight?
Correct.
Okay. Yeah, so I guess, Jen, to answer your, how do you prevent this from happening? I think there has to be something with, with Gary and the select board to certain properties, you gotta go through a review process, or you wanna be consulted when permits, applications come to that, if we don't have an official, historical district. Just the common courtesy of, hey, giving us a heads up so we can come to that planning board or zoning board meeting and, express your concerns and have those, heard and hopefully part of the end all result. But then the follow-up is just, again, lack of execution can kill you sometimes. Yeah.
Hey, Chris?
Yeah.
Can I get some clarification here on this for a second?
Yeah.
Okay, so this was built back 99, 2000. I remember when it was being built. Now, we're supposed to have wood clapboards. It didn't. They put on a composite material of some kind instead of wooden clapboards. Now they've just completely resided the building. Is that what I'm understanding?
Yes.
Yep.
Yep. And it's a vinyl product, is that what it is? Yeah. So one question is, so oftentimes when things come to us like this, there's a complaint by someone in town, and that goes to the zoning officer, who is our building inspector, and he gives them a cease and desist, or in this case would be rip your siding off and put the wood on, and then they come to us in appeal of that, cease and desist, and then we would vote that way upon it.
Yeah, that was my next question. I think that's the only way to resolve the problem.
Can we vote on this without a formal application, without a formal hearing? And that's a legal question I don't have that answer to. I mean, I got no problem hearing this and voting on this. I just want to make sure we can vote on it and our vote means something. So Rick and Jacob, you guys are the lawyers. What's your opinions, Rick?
Chris, the matter is not properly before the board. You hit the nail on the head. If there's a compliance problem, it needs to go to the zoning enforcement officer. If there's an appeal, then the ZBA can hear it, and only then. We shouldn't even be talking about it right now.
Can the building inspector approve this? Who would have
The
been?
building inspector can determine whether the building is in compliance with the decision. And
who would that was my question. So you saying that? So back in 2000, whose town's position was it to approve the order of conditions? Was it the building inspector or was it the ZBA?
ZBA.
No, it was
Because if it was the ZBA, then I would think we could vote on that.
No. If there's it was voted on 20 years ago. There are conditions. If there's a problem with compliance, it doesn't go back to us. It's up to the building inspector to decide whether it's in compliance. And anybody can appeal from that decision. It's not properly before the ZBA tonight.
There's nothing to vote on.
People can't just come in to the ZBA and say, vote on this. No, it's not procedurally correct.
Exactly. I mean,
Chris,
yeah.
there is a David on that's not David Maxon, and I'm not sure if it's David McRae. I did invite him to the meeting, so I don't know if that's him.
Okay.
The building inspector.
Okay. David McRae, the building inspector, are you online?
Or is it David Gold?
Oh, it could be David Gold, yeah. No, it might be a different David. I'm
Okay.
sorry. I wasn't sure.
I'm just wondering.
So the owner of the building needs to be ordered to do something, right? And then they would appeal to get to us? I think.
That's the way legally, I understood, that's the way we can vote on something.
Attorney Souza?
Yes, I would agree, 100%.
I mean,
I agree with Mr. Surratt.
yeah.
Yeah, it's not before the board properly.
So, you know what I'm saying, Gary? Now, unless that a member of the ZB, so in order of conditions, sometimes, anybody, part of the order of conditions, you can make pretty much anybody the person who approves those order of conditions to allow the certificate of occupancy, like in this case, the final inspection. Now, if the zoning board was that, if that was, that entity had to go out there and review and make sure the order of conditions was met, is that something that we can do at this point in time? And either agree to allow the order, the situation or not? I just want to hear from Jake and Rick if you think that's something that's.
Well, we're not an enforcement body. We can only hear appeals.
Someone needs to file something to get to us. We can't just,
Because I thought that, I gotta look through this.
Well, Chris, it's my understanding that the building inspector here would have to issue a cease and desist or an order for them to put the right thing on, and then they'd have to appeal it from there. If the building inspector doesn't act upon anything, there's nothing to appeal.
Through the
Yeah,
chair.
we don't even have the authority to act on it.
Okay, yeah, Dick, please.
Through the chair.
Yep,
Have you guys read it?
this,
The original, have you read?
yes, I have.
You have.
When I got it, it's been 4 weeks since I've read this. And I'm actually going through it now because I want to say there was something in here about Mr. Cox being the person to approve the order of conditions.
And he was on the board.
And he was the chairman of the zoning board at that time.
Correct.
Yeah, so prior to the, so item number 16 on there, page 5. Prior to applying for a certificate of occupancy, Walcott Marshall shall appear before this board for verification that all conditions in the site plan approval, to the extent that the same can be satisfied by such date, have been in fact satisfied. Do you know if that has been, is there any record of that happening?
I don't know if there was anything in the file.
I haven't seen it.
but that was based on the original building, though, right?
Yeah.
Now we have a completely separate issue with regard to a rehab.
I'm not trying to break the rules or laws here, I'm just trying to get to where we're gonna get going anyway.
I'd like to do it right now if we could.
Exactly, but I'm not trying to do anything wrong.
Yeah.
But we all know, whether it's we do this tonight or we do it in a month from now, after a whole lot of bureaucracy and baloney, legal mumbo jumbo.
We know what the result's gonna be.
We know we know we're gonna be right back here saying the same conversation. And I'm trying to figure a way out legally that we can kind of cut to the chase here, to be honest with you, and get something done. Just for the record, while we're discussing it, and members of the board, what's your opinion of this? Are you guys okay with allowing this? If the historical societies doesn't like it, but they're not, if they haven't filed an official complaint to the building inspector to ask for a cease and desist, I don't know that avenue is the way we can go right now at this moment tonight.
I think that's what we were trying to do with our letter to the inspector, was to have him enforce the original court order.
Order of conditions.
And if he
And
does,
we have not heard any response from the inspector.
And is it your opinion right now that you still want them to change that siding?
I mean, ideally, yes, but, again, that was what the original court order stated, and we want to uphold that.
Well, the letter, when I read the historical letter, it's not very decisive. And, I can appreciate you being not too caustic, so to speak, extending, keeping the olive branch out in the air, so to speak.
Yep.
But I'm just trying to, it just comes down to the matter of that if nobody complains about this, then we just keep going on the way we've been doing it for the last 20 some odd years. And until somebody complains about it, I don't know that we can actually hear it on that point unless there's some type of way that the zoning board never actually heard this and now we can do that. Yes.
Can I just ask a question?
Yep.
So obviously they're back up and running, which means
Yeah.
everything's been
They have the
signed off
CFO.
by-
Yeah.
Exactly. So how do you issue a cease and desist? Like, is that the right? how do you issue a cease and desist when
Yeah,
it's
so,
already done?
so if there's a zoning issue, or neighbor had a complaint or something like that,
Yeah.
let's say they were just playing loud music at 3 in the morning, right, waking everybody up in the neighborhood. So the zoning officer can go down there and file a cease and desist. Now, there's usually like, you have 21 days or a certain time period that they have to deal with this. If you don't appeal this decision, then the town has to take legal matters into their own hands. They're gonna continue to operate selling Dunkin' Donuts merchandise, but that cease and desist looms over their head. There's usually a time frame associated with that by the zoning officer, and at which time they would have a 14 to 21 days or a month, a 30, 60, 90-day period to file the appeal to this board, and then for us to get them on the agenda, put the notices out to the abutters, et cetera, and then have that public meeting. That, I know, is one way, in the normal way, that something like this would be dealt with.
I think the only way.
Well, Chris, on this point, did the building inspector give the final sign off on the project?
Yes,
Any
correct?
final sign
I haven't
off?
seen it,
So
but,
the project's completely done, building inspector signed off on everything on it.
yep,
And that was
That
following
complicates things.
this letter. He was in receipt of this letter prior to that happening. So if it lies with the zoning enforcement officer to issue that cease and desist, I don't believe he's in agreement with doing so.
we're doing so, yeah.
Because this was received from the historical commission while the renovation was still taking place.
Yeah, so before the C of O, he received the letter from the historical commission. Jeez.
I think this is one that the town manager needs to have a discussion with with our building inspector. Select board on that.
Well, so, where do we go from here, huh? Where do we go? So, I mean, we can, if our zoning officer, Dave McCray, did not issue a cease and desist, we cannot vote on it for that reason. And quite honestly, I don't know that we can vote on it, even if we were the board to see this order of conditions through. We don't have the information if that was ever done right now. And that's gonna take research to go back to those hearings and to those meetings to see if that was ever accomplished. It doesn't sound like it was, because there's no information in the packet we saw that took place.
I agree with that.
So, you guys legally don't think we can vote on that because we can't have that meeting now, 20 some odd years later? No, that's not a good idea?
I'm fairly certain.
That'd be a precedent-setting issue, huh? A little old Rutland, setting the bar, right? Making rules.
Chris, I think that the petitioner could make an appeal to change the order of conditions.
Yeah,
Someone needs to appeal something.
On that, and then we can act
For
on that. But I mean, we have to have some mechanism where there has to be an appeal, and they could put in an appeal for almost like applying for a variance.
yeah, okay. Yeah, I think that's the way we need to go, guys. We need some kind of application, a formal appeal or some application. We got a few forms that you fill out to get to the ZBA here. I think that needs to be accomplished, and whether it's by the property owner, like Paul said, or by the zoning officer, I think something formal has to come into us. Whether he gives a cease and desist, something has to come from the property owner.
Do you
To
have
either
to get,
appeal-
you have to get an official complaint regarding that siding prior to?
I mean, Attorney Souza just shook his head that on Paul's note that they can just come here to adjust the order of conditions. They can just request an appeal of the order of conditions. So not a cease and desist, Gary, but hey, we have this order of conditions, and we'd like to come before this board and adjust our order of conditions. We're appealing this one item, and then that's the item we would vote upon. And I think that,
Yeah, request.
Jacob and Rick, do you guys agree on that? That that'd be another means of doing
I
this?
do it. It's gotta go through the building inspector.
Okay.
I think you could also, the petitioner could also ask for a modification of the original permit.
Yeah.
Through
Yeah.
this board,
So you could do that.
prior to the issuance of a cease and desist.
And that would be another site plan
That would be another
approval. That would be another site plan approval, or
Correct.
whatever he filed the first time. It wouldn't be an appeal,
That's
it would be that site plan approval at that time
Yeah.
to modify that.
I'd,
You could do
I'd
that.
agree with that as well.
Yeah, yeah.
Which,
Okay.
that's a good, and I think that's what essentially they're trying to do right now. 'Cause we just don't have anything in front of
Yeah,
us.
in hyperspeed, you know,
Yeah.
just blow right by all the stop signs,
We
yeah.
actually have them resubmit an application for site plan approval.
Or the building inspector gives them a cease and desist, which is pretty harsh.
So my
you know.
only question with that is that we recently had a bylaw change that took site plan approval away from the zoning board of appeals. So I understand that this application originally back then was heard when the board had that. Is there going to be any conflict with the fact that the bylaw now says that this board does not have overview of that?
So,
It's
one
a
issue
different-
there, so in general, this ZBA will do special permits. I don't know if that was a special permit or a site plan approval.
It was site plan approval.
Okay, was there any variances associated with the footprint of that building and side setbacks? Because usually those come to us. When it's a zoning issue, the planning board cannot make a zoning, they cannot say, you could be 10 feet, rather than the 20-foot side setback. They do not have the legal authority in Massachusetts to do that. Those have to come to us. That's why in the bylaws, there's multiple, some stuff goes to us, some stuff goes to them. But general rule of thumb, all zoning type requests that need that variance, that bending of the rule, so to speak, that proof of hardship, that's the stuff that comes to us. And I don't know what the original, if those, that's pretty tight on a side setback there. You could barely drive a car through there to that lot line. So I'm thinking, Tamika, that maybe they came to us because it was not in conformance with the normal project.
That's a very valid.
But I don't know, that'd be a
did
question.
another-
Rick, yeah, Paul?
Chris,
We did another site plan
Paul,
approval or something when they did the, what do you call it?
That was the drive-through. They raised the drive-through there, yeah. Yeah.
So I don't know what else was put in there at that point in time also.
The columns
On the front of the
in
building?
front of the building.
That was original.
It was mandated that columns had to be in there.
Yeah. No, what we're talking about, what Paul's talking about is probably about 10 years ago, Bob, right? They came before us 8 to 10 years ago. When you drive to the drive-through,
Yeah.
they raised the concrete pad up about 6 inches so they could meet people closer. So they had to adjust the facade of that structure a little bit, lower the window or raise the window and raise the grade a little bit. So they had to make some grade changes there and just a little exterior, touch-up. That was the second permit on that property, and then this would be the third that you just completed. So there is one between this one and the original one. But that was minor and thing. But that came to the zoning board as well. So,
Yeah, Chris, yeah, sorry.
yeah, Rick, what do you got?
No, I was gonna say, my initial impression is that where this would be either a modification or an appeal or a compliance issue with a zoning board site plan, approval,
They would have to come back to us.
it could come back to us. I think if it was a brand new site plan approval, it would go to the planning board. I'm gonna say that we do have jurisdiction on this particular one,
Okay.
because it was originally a zoning board decision.
All right. So, with that being said, does that give you some kind of direction, Gary, on how to go forward with this to get in front of us in a legal form, so we can vote on this?
My first
Sorry.
thought is to consult our legal
Sure.
and to see what I have to do with that.
That's a great idea.
We haven't received a complaint, it was just questions that were asked about it.
Yeah.
I certainly agree that the order of condition should have been followed, obviously 23 years ago.
And I would like to ask Tamika, if this comes back to us, that we can research that to see if that has ever been.
Yeah, I'll have to confer with Anita to pull the
Yeah,
minutes
to
from
go way,
that
way
far
back.
Yeah,
Yeah.
but we would have them, and
You
we
know,
would just have, I
And
just
see
have
if
to
there
go
ever was a
through
meeting
them.
after this,
Yeah.
prior to that certificate of occupancy, the original one,
Sure.
that if there was a hearing to get those order of conditions approved by the ZBA at that time. But that Rick, that's before you. You got 20 years under your belt. Bob and I got about 17, 18. We can't remember who's been on longer. We've been on so long. So, but it was before us. So, unfortunately, you know.
Just as I'm sure you do, you understand, I am not here to be the opponent or proponent for.
Understood, totally
I'm
get it.
just here because it's come to my attention.
Absolutely, you can do your job, you're town administrator, man.
So,
Yep, no, happy to help you.
so I just find out, and I just want to make sure, as I'm sure you know, Chris, that I just want to make sure the right thing is done. I understand the
Absolutely.
concerns, I fully appreciate them. This was way back when it was signed off, COs were issued.
Yeah, you know, people make mistakes, right? We're all
They do.
human, we've all made them.
I do.
That's why I love you. But one thing, when you talk to town council, ask them if their opinion of voting on this the way this is tonight is correct in us not being able to actually act and vote upon that without a formal type of appeal or application of some sort, okay? Just curious, just for whatever, just to make sure, you know,
Okay.
that we're doing the right thing here. And then one other question, Jen, for you, on the second page of your letter, from the historic letter that you're on here, the last paragraph, the Rutland Historical Commission by majority vote this day appeals to the town's authorities, including the town building inspector, to ensure compliance with lawful directives and to take proper action thereto. So that statement, it's not specific to this property, so I'm just asking you, is that something that's specific for that Dunkin' Donuts facility, or is that just more of a going forward statement, Jen?
I think that is intended to appeal to the building inspector to do what you had said, either the cease and desist, whatever mechanism to
Yeah.
make the owner comply with putting the wood clapboard on the building. That was the intent of it. So if
Alright.
it's something where, if we wanted to pursue it further, we can have that discussion at our next meeting. It sounds like we just want to go through with making it right to retain what's been put in place as of now. So I think I'll bring that back to our commission and we can discuss, moving forward, are there specific properties within the town center that we would like to be conferred on if there's any changes moving forward? How do we accomplish that so we can try and avoid some of this down the road?
Yeah, and again, I think your concerns were heard. I don't think it was a matter of you not having a seat at that table at that time. I just think on the oversight of it, that's where the failure was, obviously. And if that's all we've had in 25, 30 or more, 40, 50 years, I think it's a pretty good track record. Unfortunately, it's, here we are right now today with this problem. But overall, I don't think it's too bad,
Yep.
So I don't think it's a major problem that you guys, not getting any kind of respect or any, time in the hearings. But at least the follow through, maybe the execution on the backside is something we got to work on. All right. So, any other comments from anybody on the board? Anybody else in the that's here want to comment on this matter? Attorney, thank you for your help too. Appreciate that. All right. So I guess at this time we can wrap that up and we can move on with the agenda.
Thank you, sir.
Thank you, Gary.
Thank you to all.
Big thanks.
Thank you.
Appreciate your
Thank you.
concerns, guys. There we go. We get the easy ones all the time. All right. Gotta get referee shirts first. All right, so back to the agenda, folks. First up on that agenda was the meeting minutes from the July 6th meeting. Do we have a motion to accept these, and then we can discuss any changes?
I'll make a motion to accept the meeting minutes.
I'll second.
Seconded. Is there any discussion on these meeting minutes?
Not for me.
I just have one thing. On the first page, on that little single line right there, you've got, at this time, Chris opened the meeting to public, and those comments were as follows. If you could just put after public regarding the site plan and review of those issues. So it was to discuss just the site issues. Rick, you go with the meeting minutes?
Yes, and your change is fine too.
Okay. Any other discussion? All right, hearing none other, let's have a vote. All in favor to approve the meeting minutes as prepared and amended? All in favor, aye?
Aye.
Aye.
Okay, anybody nay? Hearing none, the motion's unanimous.
Which has just had to abstain.
Okay, yeah, any abstain?
Yep.
Yeah, Butch abstain. Thank you, Tamika. Again, she's keeping us on top of things. Thank you very much. All right. All right, at this point, it's about 6:30 something here, 6:36, we can open the continuance of the hearing for Blue Sky Towers for their application for special permit. This applicant seeks a special permit for granting authorities required in the zoning bylaw for a cell tower. And last meeting on July 6th, we went over the site plan issues, pretty much mitigated and worked out all those things. There was a new set of plans submitted to us for that. All those issues have been worked out and hashed out as far as the site plan, the road construction, the compound area and whatnot. So that's behind us. And then we got into the tree clearing. They submitted a plan of a tree clearing plan that was a little not what the board had expected, so there was some discussion there. And then we continued the hearing to now.
I think it'd be important to mention, if I may, that the variances were approved and there was no appeal on any of the variants, and the appeal time has expired for that.
Okay. Also, just want to go over right now the correspondence that we received before we get into the discussion on this hearing. Correspondence, I received, the town received an invoice from David Maxon from Isotrope, and that has been squared away. The applicant is paying all those fees, all that's been worked out.
Correct.
But just for public record, that invoice is in for $32.50, and Tamika's been working that out with the attorney and David, and all that payment's going along. That's one thing we received. We also received some information regarding the Freedom of Information Act request. Some concerned citizens petitioned the select board or the town, I'm not sure how that goes.
Town clerk.
The town clerk, okay, for Freedom of Information Act. There was a letter signed by 4 town members, Keith Tuttle, Carolyn Streeter, David Gold, Jennifer Williams, to request proof of completion of required training and acknowledgement of Mass Certified Conflict of Interest laws. Request for disclosure of any business relationships by the following members of the board. Request the disclosure of any personal or business relationships in any capacity. And that's with, they've got here with the proposed cell tower. This is with Blue Skies. And a request for disclosure of any financial relationship, including ownership, partnership, shares of company holdings in AT&T, Verizon, T-Mobile, Dish Network, and Blue Sky Towers III, and all their subsidiaries. And that information, that letter, was sent back yesterday by Ms. Murphy, and that she got right on that right away, and we turned that right around to them. That is, all that information has been sent back, so they have that request as they're legally bound to have. The select board also received a request from some concerned town citizens regarding if the select board has the authority to overturn a ZBA's decision regarding this specific site plan for the cell tower. The select board, and I believe possibly Mr. Kelleher, actually reached out to town council, and town council has issued a memo regarding what the select board's legal authority is, and long and short of it, they do not have that authority to overrule a ZBA decision. There would have to be an appeal by somebody. So that's just to wrap that up. And all this stuff is posted. It's all public information. You can dig into it if you want to, but just try to roll along here to keep the generalities. We also received, Tamika informed this board, I believe it was today or yesterday, about the Conservation Commission, that there was a hearing last night. Yes, that would have been today. You sent an email out today regarding that the Conservation Commission has approved. You folks got all your approvals by Concom.
That's correct.
Everything's 100% there.
Yes.
Yep, okay. So that approval has been done. That last meeting was last night, I believe.
Yes, it was.
And that final approval was given then, last night. Okay. I know some people have had questions and concerns about near the wetlands or going over the wetlands, but all that's all been done legally in another board, and that's done. Okay. We also received possibly 2 emails, or at least one big one email from a Ms. Karen Greenwood. She sent 2 emails to the board. She requested to forward this information regarding the cell tower. She sent this to Tamika. The first one, she talks about And again, just to kind of go through these in somewhat brief manner, in general, the board's requirement to waive the 72-hour balloon test, okay? And she also talks about when the balloon test was done in relation to when they filed their application and when they had their pre-conference. So I want to point out that she actually states in this, and I'm just not really sure, she references an April 7th meeting and a July 14th meeting. In the April 7th pre-conference, we discussed having a balloon test. So that meets all the issues of the bylaw, that you have to do it, at the pre-conference or 30 days before the pre-conference, or you have to do the balloon test 21 days before you submit your application. But you came back to this board on July 14th to discuss the actual balloon test. And this board and the applicant agreed on the times and dates. And rather than doing a 72-hour window, which could be done during just a week, it was discussed to do 2 different tests during the week and during the weekend, so that people, because I know personally, I would never see a balloon test in town during the week. I don't get home. I leave my house at 5 in the morning. I don't get home till 9 o'clock. I'd never see the balloon test. So we wanted to have it on the weekends and the weekdays. And that's why this board allowed that. And we don't have to give a formal waiver for that, but we did allow that, and this was all discussed. It's actually right in Mrs. Greenwood's July, how she references the meeting notes from July 14th. So I'm not sure why she might be confused, but that was all agreed upon by the board. Also, one thing I'd just like to point out about, one thing that's not true in Mrs. Greenwood's email is that she says the application was filed on November 10th. That is incorrect. The application was filed on October 6th. The first hearing was November 10th. So now that's still not 21 days before the October, from the time the balloon test was done in August to October 6th. But it is over four weeks difference. But again, the pre-conference takes care of that. You can do it at the pre-conference or 21 days before. We didn't have to do it 21 days before. We did it at the pre-conference. So, and I'd like to point out that not in our bylaws is a requirement for 2 balloon tests. And this board did require 2 separate balloon tests. Not just one during August when the trees are in complete foliage, but one in December when the trees are bare. And that is not a requirement of the zoning board. And I'm not sure if the intent of this letter was to reference that we somehow gave favor or made it easy for this applicant, but I take serious, I take this pretty serious, that I feel this board went above and beyond what the zoning bylaws require. And I think we did an excellent job for this town, because I don't think that gets done. Two balloon tests does not happen, and did not have to happen per these bylaws. So I just want that stated for the record, please. Any other comments from the board on this? Her second email also references the rules of the zoning board, residence district, about a 35-foot height, wireless locations. We've discussed all these items. These variances were approved. We went over why the height of the tower is with the tower. I don't feel we really have to bring this back up. I'm not sure if she was, here at all these meetings, but she can go back through that. One thing in this second memorandum, and I want to point this out, that this is not true. This is false information in this memorandum. When they state, one of the reasons Rutland Heights was rejected as a location, I'm paraphrasing, is it was too close to a daycare. And they go on to say, why is it okay to be near Naquag Elementary and Central Tree Schools? I never remember ever hearing that Rutland Heights was not a location allowed because of a daycare. And in fact, on 2 separate occasions, I am the chairman of the HPDD review board, okay? And I specifically told everybody in these 2 meetings at that time that there's 30 acres under an agreement already with this town to put up 142 over 55 units. That site plan was just approved a week ago. That property is in conveyance to Harbor Classic Homes. I stated that on 2 different occasions. I don't know why this daycare even is a situation that is not true. That had never had, nobody on this board ever said anything to that degree. And I don't know where that's coming from. That was information discussed about people, but that is not, that is just not the reason, and I stated that reason twice. That is over. One other thing, somebody put in, this memo goes on to say that some of the alternative sites state they were too close to wetlands to have cross wetlands. Why is this being allowed for 12 Phillips Road? Other locations that they submitted were near wetlands. They were rejected, and the consultants, the applicant's attorney, and David Maxon agreed with the consultant that they were rejected because of they didn't meet the criteria from an RF standpoint. Had nothing to do with wetlands. Okay? This property is located, they have to have a wetlands crossing. It was approved by the Conservation Commission last night. That is totally legal to do. You can cross wetlands one time on your parcel. That is nothing new about that. That is perfectly legal to do. It's done all the time. So, just to point out a couple things here, that I think there's a little bit of misinformation in this memo. Not sure where they got it, but we're going to keep moving on here. That's the Karen Greenwood's issues. We also got two. We also got two emails.
Question, please.
Yes, ma'am.
All right, Karen Greenwood, 7 Breezy Lane.
Yep.
And the part where you mentioned about the daycare and the alternative sites, I got that from the report that they submitted. It was part of their application, exhibit number 5, where they gave an alternative site analysis.
Well, as this board never discussed that.
I read that.
This board never discussed that issue, never brought that up. It was not by this board. And for whatever reason, they don't want to put something with it. That's their business. But I can tell you right now, Rutland Heights is not happening because we don't own that property. So just so you know.
And that's not what I was getting at. I was only reading
Thank
what
you.
they
Thank you for
submitted.
clarification. Item number, one other thing here. We got 2 emails from Ms. Streeter. One email references that she's getting groundwater issues, that she's had groundwater issues on her property. That's really, groundwater is a problem everybody has on their property, and sometimes we've discussed this issue as far as groundwater goes. That's a 12 to 14 acre parcel. The hole in the ground, again, for the 3rd or 4th time I've stated this, that hole in the ground they're going to dig for the foundation is no different than someone digging a hole for a home. And that parcel could have multiple homes. So one home on 14 acres is a lot better than 12 homes on 14 acres. And whatever, if that would cause any water damage, which that is not an issue here. So just want to put that to bed. We also received from Ms. Streeter an email about 12 Phillips Road. Rich's references here. Antennas added to the tower by other carriers will be in lower suboptimal positions and can be experienced to provide less expanded coverage. I think our consultant said between the 96-foot mark and that 120-foot mark, everything would work. Their consultant agreed. I don't agree with that statement. I don't think that's correct. There's also an issue here. She references about the coverage maps, that there's very little difference between what's going to be covered and something that, if you guys remember the white on the coverage maps, that that was not coverage, but again, AT&T lawyers stated that the white zones do not have coverage, which is untrue. Well, I would agree with you, that's untrue, because the attorney and their consultant said there is coverage in those areas. Okay? And that was discussed.
One of the things I think people are confusing is cell phone coverage with data. And it's transmission. Data takes up a lot more bandwidth. Yes, you can make a phone call, and anybody that's been uptown on a Friday night knows that you can't access the internet via your phone. It's extremely slow. You can make a phone call, you can send a text. If you attach a picture to the text, or you try and go on to any social media site or try and access the internet, you'll find that you can't. And I've done this myself to test it. So we're not talking about just cell phone coverage, we're talking about data. And data takes up a lot more bandwidth than cell phone. You can make a cell phone call with 1 bar, but you can't do anything else. And that's where the coverage increases. So just to clarify that, from the scientific side, I think that's where people need to.
And also, just to clarify, on her 3rd paragraph, she references the tower standing 120 to 140 feet. We've already only allowed a 120-foot tower with a 1-foot extra lightning rod at the tip. So 140 or 120 to 140 is not what's allowed. It's not what we've already granted a variance on. So again, I'm just trying to clarify this misinformation and make sure things that have been written and are put up on the public, that it's just clarified. Again, she's been to every meeting I don't know why this information comes in like this when it's not very accurate. It's somewhat frustrating, but regardless, I just feel the need to clarify that to make sure everybody's on the same page here. Also, she references that the height of the trees are 50 to 55 feet, but the drawings and everybody's agreed it's 60 to 65 feet. So again, just some clarifications, and want to make sure that those emails, that information gets clarified as it's put up publicly. Any comments from the board on any of that correspondence so far? Okay, and the last two things that we received correspondence on was from the applicant. His attorney sent us an updated tree clearing plan. Tamika was so nice to have for us here. And also an updated order of conditions. So at this point, I'd like to start this hearing and get some discussion going regarding the tree clearing plan, attorney.
Okay.
Do you want to just kind of
Okay.
give us a brief synopsis of what you submitted?
I can, and Mr. Chairman and members of the board, if you don't have extra copies of the, first of all, I think it's important what we call this. It's not a tree clearing plan, right? There's no current plan to remove trees. It's a tree buffer plan. And I think it's really important to look at it that way. Oh, you have one. Fantastic.
One thing, just to clarify that statement,
Prescription glasses.
I would like to just say that the tree clearing was discussed on the site plan drawings.
Yeah.
There is a tree clearing clouded area, and I specifically did talk to, I believe it was Tom, who's your civil engineer.
Tom Johnson.
Tom Johnson, and it's in the meeting notes, and I have that written down here.
Yeah.
That on a particular occasion, I did ask Mr. Johnson, like, this is the limit of your tree clearing. Because I thought it was really close for the electric utility overhead lines particularly.
Yep.
That they were gonna want a little bit more clearance there, attorney. And he said, no, everything, the way that's marked out is the way we're gonna cut it. So, this is in addition to that plan, not just the sole plan, just to be on the same par. That's what we had been working off of on the site plan to date until you submitted this at the last hearing, just so you know, just to clarify that.
And just to even further clarify beyond that, or just to respond to you, first of all, Mr. Johnson, Tom Johnson from Proterra is on the line.
Good.
He can help answer questions. In addition to that, Mark LeBouf here, representative for the landlord. There's some indication from the board that you may want to ask him some questions, because he's not trying to hide anything. And I think we want to try to be reasonable with you and try to find a solution that works both for the town and for the petitioner.
Sure.
I think Mr. Johnson, when he was talking about the tree clearing, was talking more about the access road. That's
Correct.
That's exactly what he was talking about.
Yep.
With respect to what trees would be removed to build this access road
that in the
to
compound.
the compound.
Absolutely, I agree.
Exactly. And so the buffer itself tries to address one of the concerns by the board, which is an important one, which is making sure there's enough vegetation on the lot to hide the tower, right?
Correct.
And
And I
so-
believe, just to clarify,
Yep.
we have a 50-foot buffer
Right.
in our bylaw.
Right.
That's required, a 50-foot buffer around a cell tower.
Yeah, I was going to exactly point that out. So if you look at that,
the
section
minimum.
56B2, it actually states a buffer of at least 50 feet is desired.
Correct.
And so what we gave you actually in that plan is 150 feet around the tower. In addition to that, we've also gone one step further, and we've built another 50-foot buffer around the entire perimeter of the tower. And we think that's a responsible effort to make sure that we, in the future, if there is tree cutting, that we minimize the visibility of the tower by maintaining that no-cut area.
Yeah.
We think that's actually, if you think about it, there's about at least 450 feet on each perimeter around the tower of land. So we're going 9 times the minimum set in the bylaw.
So
If you think about it from that
we're
perspective.
talking right now, I remember seeing your email that there would be no tree cutting other than minimal needed for the road and the tower
Yeah,
site
right.
inside the yellow square. Am I correct?
So during
Inside the yellow square,
yeah.
they can cut.
So during construction, we're
So
going
see
to
the red
make
circle here?
yeah. During
That's the
construction,
150-foot buffer, they will not cut anything. And then see from the lot line, the green line to the yellow dashed, that's an additional 50-foot buffer they
On the
will not
outside.
cut. But anything within that yellow line to the red line, 150 zone, they would have the ability to clear and do what they want with.
The landowner
The
would be able
landowner
to
could cut
cut
down.
harvest.
exactly. However, that's inside the buffer
Yep.
that you have to maintain a tree.
A dual
trees
buffer
around.
zone if you.
Exactly. Above and beyond that, there's also restrictions from a Conservation Commission perspective. You're not supposed to take down trees in the conservation area, in a wetlands, without permission of CONSCOM. So there are a lot of built-in protections through the law, CONSCOM regulations, but above and beyond that, I think this effort by the petitioner to really restrict any major tree cutting that would allow for visibility of the tower, I think is extensive. It's well beyond the minimum standards set by the bylaw, and I think it addresses comments made by the chairman and by the board, and goes a long way. And so that's why we respectfully modified the conditions from the last hearing to, I think, address those concerns and to replicate what's being told here on the plan.
Yeah, and one major difference, just to point out to the
Sure.
board, is this is now a square buffer, where the last plan was a
Yes.
U buffer.
That's right.
I believe it still had the 150-foot buffer around the tower.
It did.
And just that, this was just kind of shaped like a U, if you remember.
Yeah.
Like this was not, there, that piece in the middle there. So, again, at this point, anything else to add to that, Johnny?
So that's what I have with respect to the buffer.
Sure. Yeah, let's just talk about that right now.
Of
Keep the order of
course, yeah,
conditions
I'll
off the
sit down
side.
and let the board
Yeah.
talk about that.
Because I think this is an issue we need to get through as a board, because this was a major problem.
What is this green?
This green is the wetland
It's the wetland,
buffer.
100-foot setback.
Yeah, so there's
To wetlands.
around, so this green goes, see this blue right here? This green is a 100-foot buffer from that blue line to the green line. Yeah, so this is a 100-foot buffer right here, from here to here,
So it goes-
and then from there to there, okay?
So here,
Yep.
here it goes over.
Yeah, well, this blue shaded, so this is the real blue line right there.
Okay.
This is just a little fuzzy area.
Oh, okay.
Yeah, and it's important to note, just with respect to a comment that was made, putting one tower there is better than 12 or 13 homes. If you look at the wetlands on this land, it would be very hard to put anywhere near that number of homes. There are very few dry areas. One dry area is where the tower is. So, to your point, I think that addresses, a goal of the board. But there's very little place to put any structure.
And I was just
Not
referencing
wet. Of course,
groundwater.
yes,
Obviously, by digging a hole in the ground, that might displace groundwater,
right,
rather, which is the same volume as a house foundation.
exactly.
And you could have multiple, maybe not 12, but you could have
It's
like
actually less.
3 or 4 here.
They're going with the slab. It's less.
Well, they gotta dig a 30 by 30 hole in the ground. You gotta put a concrete base there, that goes down.
Yeah.
No, it goes down.
Yeah, we just
I mean, you
discussed
got
that.
footings and all, but
Yeah,
you're
it's
not-
just giant,
you're
it's
not
one
digging
giant
an 8-foot
block.
Yeah,
It's
you're
just
not
one giant
You're not
block.
digging an 8-foot cellar hole, is what I'm telling you.
So, this to me is, again, I stated my opinion on the last meeting that, being able to clear that many trees is just really not too acceptable for me, to be honest with you. And my opinion hasn't really changed. I like the effort, and I'm glad you guys, got a new game plan and came back to us with something, but that's my opinion. I just want to hear the board's, anybody else on the board? Rick, do you have any opinion about this, where you stand?
Well, Chris, I respect your position. I think the applicant's efforts are acceptable in my eyes. I think their plan is going to provide enough cover for the tower.
Okay.
Can I ask the representative of the
Please.
landlord question?
Sure.
What's your opposition or to saying you won't clear that lot inside there?
Well, may I go off subject
Please.
a little bit here?
Yeah, and if you could, Mark, just state your name and address for the record.
Yes, I'm Mark LeBoff at 12 Phillips Road. I brought some pictures along with me as well, if you mind sharing with the board. When it comes to tree cutting, these are the trees that I'm referring to. I feel as though, and I have some in a collage for any of the towns, people would like to see it.
Thank you.
I'm gonna sit if you don't mind.
Please don't stand for us.
Yeah, it's got a little bit of bad back, so. No, I sit quiet through these meetings. I'm here just like everybody else, trusting the board to make these right decisions to protect everybody in this town. I can't agree with you more on a lot of this stuff, but when it came down to the demands of the tree cutting, the subdividing, and the further development is kind of where I became involved. There's no intentions on clear cutting of this land. The land has had a selective harvest. It's been done in 2014, I believe, 2014-15. There was a cutting plan, all that. And I'll show you, it was a friend of mine, and I made his life very difficult. This is a large chunk of land. It's been my family for a long time. If you notice in some of the pictures, there's a very well-maintained trail, heavily used. We do a lot of recreation. My family, my neighbors, we really enjoy it out there. And I didn't want to lose that property in a way of financially. This is my inheritance, and I'd like to protect that. Building houses would be an alternative. Well, then I lose the property. Clearing it, I don't have the trees anymore. If you notice in the picture, it's, the large growth is gone, and it's growing up
Yeah,
very
it's not
well.
gonna-
It'd be a long time before we could send anything to a sawmill. I do cut firewood, and I can tell you, I don't think I've ever cut a tree for the sole purpose of firewood alone. It's the ones that need to go down anyways that are gonna cause harm. If you can see some of those, they're ready to go, they're dead, they're dying, they're gonna fall anyways. It's a lot easier to take control over one, it's a lot safer to take it down when you do have a little more control around it. Or you see some that now have gotten caught up in the top of other trees. Now I would have to take down a perfectly healthy tree to remove this dead one. So I guess what I'm saying is, Chris, to go with some of your words, like, can we put a leash on this thing? Can we rein this in a little bit? I take things very literal, and I think my butters will as well. So if there's something hazardous, I know you guys would probably be okay if it's gonna fall on my house, I could cut it down. I come ask you to say yes. If it's gonna fall on my son, my family, I'd like to have that option. That's all. I wouldn't like that taken away from me.
So would you be opposed if, say, there'll be no cutting except for environmental management?
Thank you. Yeah, it just seemed like a very broad statement, and then somebody on the board mentioned, like, you can only assume that I could clear cut every single tree, and that's a safe assumption. But me agreeing to no cutting, no subdividing, no further development, I can only assume I would never get that back. I would never be able to cut that tree that's gonna cause harm to somebody. And as far as further subdividing, there's been thoughts of putting in agricultural. I've thought of before, ways, I mean, we can all agree. Price 11 or forestry, which we would have to subdivide to do that. I've done some research on it. What I come to find out is farmers
So
kind
the
of
tax
struggle.
break, like a
Yeah,
61A.
61A.
Yes, but we're paying a lot of taxes on this land that's getting progressively more wet. And it's just getting out of line, and I'd like to protect it, I'd like to keep it. So
Sure.
like I'm kinda, I feel like we're here for the same thing, in a sense.
Yeah.
But I understand where you're coming from, assuming that I would have the right to go do that. All I can give you is my word. I thought showing on that map, the 50-foot buffer, the 150 feet around it would be enough to say, hey, I'm willing to protect it.
So you'd be okay with, it wouldn't be subdivided for the purpose of using, home building?
No,
Something
yeah,
along those.
exactly.
So I think we're on the same page.
Yep.
If we could just define
You
it.
know, just not to interrupt, but David Maxon brought up a great thing last meeting, where that if you wanted to do something, you had to come to the board.
Yeah.
And, obviously tree management, I mean, that's not an issue. I mean, the health of the forest is a good thing for actually the protection of the coverage of the cell tower, as much as it's a safety issue for you people using your property, which we're not trying to take that away from you by no means. But hopefully you can understand our position, where we just let you, or someone in perpetuity that buys this property from you, heaven forbid something happens to you, sir, and that property gets auctioned or sold off to somebody else, and now somebody comes in with a whole different intent to that property, doesn't have the same personal, emotional value that you appreciate that land with right now with your son, and, and God, it's great, that's what I love to see, that's what's
So
great
how-
about Rutland.
how can we protect
But, we have to protect these other people from that as well. So I hope you guys can understand that. So, again, I looked at the legal eyes here, and to come up with some language
Yeah, Mr.
that we
Chairman.
can bridge this. I think it was
Yeah.
a great opinion. I don't know about you guys. I certainly can't disagree with anything you said.
Yeah, Mr. Chairman, just with response to that, I do agree with Mr. Maxon in the sense that he said the course of action would be to come back to the board every time he wants to cut a tree down. If we could try to anticipate in advance
Yeah.
with some exemptions,
Yeah.
to essentially
Like
say.
management, exactly.
Yes, there would be
Yeah.
exemptions for responsible tree.
Because you're gonna have to, if you go to
forestry
61A, you have to
management.
have a forestry management plan anyways,
Right.
right?
Yep, exactly,
So-
and then an exemption for 61A as well. That would be helpful. So these advanced exemptions, otherwise,
See, whatever it is, yeah.
I
The
thought
tree growth tax.
chapter 61,
Yeah.
for forestry. I
It's A, B,
think,
and C, and
yeah,
I think A's the field.
I'm not an expert in that area.
Yeah, I think C is the just
There is
the,
no C.
there's B, I know that.
There's A and B.
So
I
B is
thought-
the forestry and A is just the.
No, A, 61 is forestry, A is land, and B is recreation.
So, anyways.
So
that's
under chapter 61, if we could have that language in advance, that way he wouldn't have to take the extra effort of coming back before the board.
Yeah, I don't want, every time you wanna,
Right.
cut a dead pine tree down for crying out loud. You know,
Right.
I don't wanna really know about it, to be honest with you. I don't think it's an issue, it's dead, it's really not giving much of a, help to, in fact, it could tear down a good tree that's actually protecting the visual of this.
Right.
Right,
Yep.
that's
I
it.
think we can come up with language on that very easily.
Okay. All right,
Would you be-
Rick, what's your opinion on this?
Chris, are you asking me, Chris?
Yeah, yep, yep.
Yeah, I wasn't sure. Okay, I think, I get the strong sense that this applicant is making every effort they can to satisfy your concerns. And they don't seem unreasonable to me.
No.
That said, you know, the language, about substantial tree cutting, it's a little vague. Maybe we could spend a minute or two cleaning that up and come up with more precise language. But other than that, I think it's pretty reasonable. I mean, you can disagree, and I'm fine with that. But I think
I agree.
they're really working with you here.
Yeah, no, I completely agree with what you said. Jacob, legally, you guys,
Yeah,
what's your opinion?
I'm in agreement.
How do we, Bob, you kind
Yeah.
of feel the same thing?
Sounds like he's willing to work with us.
Yeah, Paul,
Yeah, I know, it's what,
you got no issues here. So how do we create some verbiage here
Mhm.
that just doesn't let somebody go on a tree cutting spree here? You know,
I think it's.
oil goes up to $10 a gallon. This guy wants to cut firewood for him and his family this winter, and
I mean,
mows
just-
down a couple acres, and we gotta.
Does forestry management, is that enough? I mean, that was what Paul thought of, you know?
I
Other
think-
than forestry management?
Does that work for you? Does that give you enough flexibility to do what you need to do?
I would think so, that would cover it, that's the only intent.
No cutting of trees other than for forestry management.
Yeah, or in compliance with a forestry plan approved under chapter 61, something like that.
And the subdivision would be limited to, what is the,
Subdivision would be limited to the carving out of the existing home and garage to place the remaining property in 61, in chapter 61.
And there's also another issue that goes along with, if you look at the,
You also want another lot, didn't you? You mentioned
Yes.
last meeting.
I think,
so like I said, this is my inheritance, and the lot close to Maple Avenue.
Is that this chunk down here, sir?
Right,
you can approach the board.
Yeah.
right here. This, it would be this that's already cut off here.
Oh, that over there,
Yeah.
okay.
So this would be.
Is that already, separate lot?
It is currently, but to make that useful, I would have to give some to it.
You'd have to grab some of
And
this.
that would be my mother's inheritance. And,
How much would you have to give?
I couldn't tell you exactly, but my assumption would be to somewhere across here. And give
Flush
that.
with your lot line?
Yes, pretty
So
much.
the way
It
yours
came down
breaks off,
Fairview
right?
Avenue.
Flush with
Yeah.
Fairview, right?
Across
Yes.
Fairview, okay,
Yeah.
yep.
And I know it was mentioned before too, that maybe those trees could affect the site of the tower. And we referenced to the balloon test, but I also can show you that on December 16th, it was 2 days before the second balloon test, may I say something? We removed a substantial amount of trees on this property line behind the house. It was large ash and a lot of cherry that was getting very dangerous, very mature, gonna hit the house. So those pictures, that was done 2 days before that balloon test, and it seemed to have no effects on the
I
test.
think earlier we were talking about, we were really concerned with this here.
That
Yeah.
core is
This
the
part
main
of the.
area.
this
That little
part of
wing
the
down
lot.
there, I
Yeah,
actually
we're-
did a drawing up to say, like,
Right.
if you just wanna carve out a house, I would like to see you leave a buffer there.
Yes.
You know, when you do it, just don't
Right.
bone that thing to the lot line, but,
Of course.
you know, if you can leave some
Right,
kind of,
right.
I don't want you not to have a yard either,
That-
but,
some
And-
proposed language.
And as you can see, even a portion of that pork chop handle is in the wetland buffer.
yeah.
Right.
So
It might not
really
even
not
be
gonna mess with that too
Correct.
much, just like you said, you're just grabbing square footage to make the other parcel really where you're gonna put the
Potentially.
house lot then. Is that what
Correct.
you're saying? Okay. All right,
And so those are the
intentions are good,
modifications.
but intentions, only go so far in a quarter law. And that's why we have attorneys.
Yeah.
And, you know, you know.
And that's why this
Personal.
language would be, you know, included in any decision. And
Yeah.
that would be running with the land. So even if it's sold from this family, it would still run with the land and be conditions that bind the special permit.
Okay, so I think Paul just wrote some notes down here. Subdividing a property will be limited to Chapter 61 use to carve out your residential parcel to the amount you needed, and then put the rest of it in 61, Chapter 61, sometime
Current
form of
use.
Chapter 61.
Correct.
And then potentially also, Paul would add to this, that lower little pork chop piece.
Yeah, but I mean, I think we're really, when we're talking about the exemptions and stuff, on the thing, when I, you know, so I left the blank here, zone, I mean, in the yellow zone is what we're really concerned about. How do we delineate, or what do we call that yellow zone?
You could say no further subdividing within
The buffer zone.
The buffer zone.
That's the buffer zone.
yellow
That
buffer
whole
zone.
yellow, green area.
Yeah,
is the buffer-
exactly.
Okay, so we just call it the buffer zone.
Yep.
All right, so you use the, that's a.
The 50-foot buffer zone surrounding the property.
Yeah,
Say
and
something
everything
like that.
encompassing the 50-foot buffer zone.
Correct.
That's something we can work up.
Cutting of the trees within the buffer zone, because that also kind of it doesn't put any restrictions on that.
No, we're just talking about subdividing the property right now. That's
Yeah, that's what I'm
the
saying.
one issue. We're not talking about cutting any trees down.
No,
That's a separate
I'm
issue.
just saying, but the whole thing, if we refer to everything as the buffer zone, we don't even have to worry about, you know, or giving.
As far as subdividing, no, that's why.
We don't have to
That's
worry
true.
about
That's
that.
a good point. That's
Yeah,
a good
the
point.
pork chop or what he does with his lot, that's
Yep.
just down the, they can do what they want.
Absolutely, I agree with that, yeah.
But what we can do outside the pork chop, outside the buffer zone, how do we handle the tree clearing outside and inside that buffer zone? How do we word that? Because
Cutting of trees within the buffer zone, which is what we're really talking about, this square here,
yeah,
will be limited to forest management and maintenance of existing trails.
that's not very. I mean, forest management. What does that mean? Forest management says cut everything. You can cut everything. I mean, what does forest management mean? I don't know. I don't know what that means.
Attorney Souza, can you think of something else
I-
as far as language?
Yeah, I mean, the language that we could use is no substantial tree cutting and consistent with responsible forest management.
Maybe
Both of those concepts.
Any significant tree cutting is prohibited, other than a limited amount for the purpose of
Could you say no more than
forestry
20,
management.
25
And what's the time? Like, so in other words, if you even said like, hey, the guy can't cut more than 4 cords of wood off his property, and what's the time frame?
I mean, could you?
4 cords is a measurable quantitative quantity.
But that's not, I mean, that's getting outside of what we're talking about. They're not talking about harvesting that, you know.
That's what he was talking about. He was talking about cutting down cordwood, firewood.
Yeah, well, like I told, I mean, like, it's only my word, but I have never cut a tree for the sole purpose of burning it. It's always, there's plenty down, there's plenty that need to go down. I paid for $6,000 worth of trees behind the house. I got plenty to burn for a little while. I know it doesn't mean much to you, but if we could put a number on it, I believe there's an amount any homeowner is allowed to cut without a cutting plan. I don't know what that is, it in cordage, if we could.
Just trying. I just thought.
Yeah,
shoot
there's
something
technical
out there.
sides here.
How else do you measure trees, Dick? Right? I mean,
Yeah, Dick, you might know.
without getting the
Is
actual quantity of a tree, which that just seems ridiculous.
Yeah, I believe it was 15 cords.
50, I thought it was 10, but yeah.
What's that referred
That's
to?
a long
Dick? 10 cords of what?
15 to 10 cords, someplace in that neck of the woods. But don't forget also, when you have 61, every 10 years you have to re-up the 61 with the
Yep.
town
Correct.
forest management plan too, so.
Right.
So if
That's
they're
a good
doing
time
61,
to have the
Mr.
forest
Chairman?
go
there's gonna
through.
be a management plan in there anyway.
Yeah, if he
David,
goes,
Matt?
if he goes in for forestry, you have to have a management plan in place for them to accept you at the 61. I know that because I have
Correct.
property in town.
Yes, absolutely.
And you have to have a forestry plan in place. You gotta hire that, there's a guy in Holden that does it or whatever they want you.
Chris, David Maxon is trying
Oh, I'm sorry. Thank you, Tamika. Hi, David. Please.
Hey, thanks. I've been keeping quiet, but I just looked up a term that is commonly used to make sure that I understood what it meant. The term selective cutting is defined as the cutting out of trees that are mature or defective, or of inferior kinds to encourage the growth of the remaining trees in a forest or wood. So perhaps you could simply refer to selective cutting.
Any cutting of trees is prohibited unless for selective cutting of trees.
Yeah, or only selective cutting is allowed.
Okay. You okay with that?
And with that definition, Timmy, could you get that?
Say only selective cutting shall be permitted within.
And Dave, where is that defined, if you don't mind, for the board?
Well, I just looked at a Merriam-Webster, but
Oh,
it's
okay.
a term that I've heard used. I think it was
Yeah.
way back. There was a similar issue in Ipswich many years ago, and the folks maintained it as a woodlot. They do selective cutting. They never intend to clear cut it, and so that was the terminology that they put into the condition.
Okay. Sounds acceptable to us as well.
And so
Only selective cutting of trees is allowed.
within the buffer
And you could
zone.
even say any
no.
substantial cutting of trees is prohibited.
In any areas other than the 150 foot and the 50-foot buffer zone. Because just within that buffers, we don't want them cutting anything down in the buffers, do we? Or we don't allow them to do that in the buffers too?
Well, I mean, if it,
How do we handle that 150 and that 50-foot boundary? Is that all part of
I
this
think
too?
the selective cutting would, I mean, you got a tree that's starting to come down.
Yeah, I mean, you gotta deal with that too,
Yeah,
right?
it's under selective cutting.
Okay, just wanna make sure we're on the same page.
Yep.
It's actually keeping it healthier.
Selective cutting on the whole parcel.
Yeah, in that buffer, that whole
Yeah.
buffer zone.
But that buffer zone that's the area
That's the no cut area.
that's the,
Probably
that's
match,
the,
yeah.
you know, you can't go in there and
Wanna
take a live
protect
tree
that.
down for any reason.
Correct.
That thing's gotta be dead as a stump.
Yep.
Just to clarify, the trees that we're looking at are like the ones you showed us in the pictures.
Yes.
Okay.
Yes, those are what I'm concerned about. And also, just tree cutting is very vague too. I mean, is there a height on a tree that we're gonna say within that zone? I need to get through and I get a sapling, can I take that down? Could we put a height restriction on it or something like that, just to kind of rein it in?
It's a
here.
reasonable request. It's a reasonable request.
The idea of this buffer
would-
to me was like establishing a fence in
I would think
direct
something-
response to clear cutting.
Something that's 20% of that height.
Okay. I mean,
Like, so in other words, if the tree in that area is 60 feet, you can cut something less than 20% of that height.
You wanna just
So
call
just
it
call
no
15 feet.
tree, call it no tree
Call
over.
10 feet or something
under
like
20
that?
feet.
Yeah.
excuse me?
You know,
10
10
feet
feet.
still, 10 feet's still a very immature. Say no tree over 20 feet or over 15 feet.
Well, no, he wants the ability to cut a tree that's small.
Right, so.
To get-
right,
to
I'm
get
saying
access
you
to an
cut
area.
no tree over.
Yeah, exactly, over 15 feet.
I may have to cut some smaller ones around a dead one
Yeah.
to be safe.
Yeah,
is
no,
all.
That's 25% of the average height there. We know we're 60 feet plus
Yeah.
there, so.
That makes
You know,
sense.
15 foot's 25% of the average height. That ain't gonna wreck your forest. And Dick, I'm gonna ask you, because you're a woodsman expert here. Does that sound like a reasonable height and a
That's
reasonable?
reasonable. And
Yeah.
question, how,
David, does that sound reasonable?
It sounds like a way to go. There's another qualitative term of art here, which is understory vegetation, which is basically anything that's not growing up to the tree canopy, up to the main canopy. That they could clear understory vegetation.
Understoried up to 15 feet,
I'm sorry, okay.
all right?
Okay.
especially invasives.
Yeah, and that was part of the selective, invasive, like,
Yeah.
can be removed.
Yeah. a lot of
Just
that.
to let you know, from my house, I can look off down towards Worcester and West Boylston and cell towers around. And lately, I've been seeing pine trees growing like crazy. So I don't know how tall your tower is supposed to be.
120 feet it'll be.
120 foot. Some of these trees are starting to get, really up there. So it's just interesting to let you know about that.
Yeah.
But it's pine trees. It's been
That's the other thing, clearing the underbrush around is gonna let the trees get larger, more healthier, more cover.
Okay,
I've
All right.
seen the pictures growing very well since
So-
2014.
I think for all intent and purposes, we can, we as a board, that we're in agreement that we're wording up an order of conditions to this thing is something that we agree upon.
I think Jacob's been
Been taking notes over there pretty
going
good,
down,
hasn't he? Yeah, yeah.
setting the order of conditions there, or, well,
Making some notes.
yeah.
Okay,
And
So-
those two, if we have different for.
So let's kind of, next thing I have is kind of to slide into the order of conditions and discuss those and kind of get those finalized as well. And then after that point, I'd like to open it up for public discussion, but I'd like to get all this information out there prior to the public commenting and having their opinions heard, okay? Just so everybody, that's kind of the way, unless there's anything else to discuss, but I think those are this tree issue and the order of conditions were really the last things to discuss. Does any board member have anything else to discuss or review or anything like that?
No.
Okay. All right, so let's slide into that. Attorney, you prepared an order of conditions. I have my notes. We have many other notes here.
The email I sent on July 28th.
Find that.
I got
All right. Sorry about that. Sorry. Okay, so, first up was, to discuss orders of conditions. First up was, on Attorney Souza's memo, was during construction of the tower, the applicant shall use commercial reasonable efforts to minimize tree removal. The tree removal will generally follow the access corridor in the compound area on the plans and will allow for trimming and removal to protect such areas. Necessary clearance around utilities in the operation of the tower. Is everybody approved with that?
Yes.
And that's in accordance with the plans you submitted?
That's right, in accordance, and you can even say in accordance with the plan.
Yeah, I think that's
If you
excellent.
want.
Yeah, let's do that, in accordance with the plans. Add that to it. Okay. Number two, after the tower is constructed, the owner of the property shall not remove any of the trees on the property within the tree buffer delineated in the tree buffer plan submitted by the applicant. Area marked in red and yellow, including the 150-foot radius around the tower and the 50-foot no tree buffer removal on all four sides of the southern portion. So this one, we're just gonna table this one, we'll amend, add language to that, to just controls what's going on in the other areas.
Correct, yeah, what I anticipate is just except for selective trimming, right, which was
Yeah.
the language.
Yeah, let's get through everything else here and leave the beast for last, if you don't
Okay,
mind.
fair enough.
Selective cutting.
Selective cutting.
Selective cutting, yeah. Okay. The property owner may only subdivide the remaining portion of the lot north of the tree buffer to form and portion off one additional lot, subject to obtaining all permits and approvals required by the town. The property owner will minimize the amount of tree removal on the remaining portion of the lot, and any substantial tree removal outside the buffer areas require the approval of the planning board. I'm not sure that should be the planning board or the ZBA, the zoning board.
Okay, it could be the ZBA.
I mean, that you'd have to almost come back here for like an amendment to the plan,
Yeah.
right?
Yeah,
So
it's
I
just,
think that should be,
right.
okay.
The only reason I put the planning board is typically subdivided plans are in the jurisdiction of the planning board, but. Because, once again,
You just put the appropriate board.
Chris, do you want to
That
say
will be the planning board,
appropriate?
It would for an A&R, yeah, which is how he would subdivide it.
So, a lot of times though, they gotta go to the planning board and then they gotta come to us.
Nope, not for an A&R.
Not for an A&R, but I'm saying on a site plan sometimes, like sometimes they have to go get their plan
Another
approved,
board.
and then if they wanted to do something that was zoning related, they might have to come to us.
Well, zoning, they come for us for setbacks or whatever
Yeah.
else, but not for site plan approvals.
Yeah.
completely off us.
and I think there's one way to simplify this condition, which is
Appropriate board.
exactly what Mr. Kiernan said, which was property owner shall not subdivide the portion of the lot within the yellow tree buffer
Yep.
at all.
Yeah.
Right?
Yep.
Which is what I think the board suggested.
Yeah.
Rather than getting into how we can subdivide it and who has jurisdiction over it.
Okay. You got that, Jake, are you,
Trying.
okay.
Did we say though with the exception
Yeah,
of
we'll stenography it for you.
61
Correct.
Sections, with the exception of 61, section 61 uses.
Exactly, with the exception of placing the property
Chapter 61.
into chapter 61,
Correct.
current use. Yeah,
And the one thing here, one additional lot, but you also want to carve a piece off as well. So that's a little, I think you need to address that too.
you could.
Approximately, to the Fairview line there.
Yep, exactly.
And I think that should be stated in this as well. So, you want to carve out your lot for your home and put everything in chapter 61, that's fine. And then if you're going to increase the size of the other lot for area to put a house on that lot, I think that ought to be stated in here as well.
Well, but Chris, we say just, within the buffer zone, means outside the buffer zone, we don't care what they, it's outside of what we do.
True.
Right.
So as long as we just say everything we're doing is in the buffer zone,
Yeah.
let's leave the other stuff away from it.
Yeah, not get too complicated here.
Yeah.
I'm with that. That's simple.
Chris,
Yeah, Rick.
I took a quick look at chapter 61. I mean, that has to do with taxation on land. So I don't feel comfortable citing chapter 61 if I'm going to draft this decision. If the rest of the board wants to overrule me on that, that's fine. But I don't know where 61 comes in.
Well, the only thing they're just referencing using the remaining parcel. So if the landowner cuts out an 1.5 acre piece that's around his home right now, his existing home and garage, so he can put the rest of that parcel, the other remaining 12.5 acres, into chapter 61. That would allow him to subdivide the property to do that.
And you could say even further, Mr. Surratt, that, the board makes no representation regarding the qualification of this property for acceptance in chapter 61.
Yeah. We're not saying that he's legally, allowed to. Yeah, you have to meet the requirements to get into that, and we can state that. Yeah.
Okay, all right, I'm fine with that.
Okay. All right. I just think the 61 keeps it, almost it keeps it conservation land,
Right.
which is kind of.
It's your benefit.
It's really, it's to our benefit to maintain these
Okay.
trees and, the best interest of the public. That's all.
Okay, I don't
It's
know
kind of a
if
tool, we're just kind of using that to
Okay.
leverage this, that's all.
but
I'm not trying to
Okay.
tell him he's got it, but.
fine.
Okay, so that's good enough there, Jake?
Yes.
You get your grip on that? Okay. All right, item number 4. The height of the tower shall be limited to 120 feet in order to minimize the visibility of the tower, and that such height is a unique condition of this decision to preserve an aesthetic benefit to the town, and that any further extension of the height of the tower shall require an amendment to this special permit from the
zoning
ZBA.
board.
That will definitely be ZBA.
Yes, I apologize.
That's fine. That's fine with me.
Yes.
I agree with that.
I was trying to
don't
address
think-
Mr. Maxon's
Yep.
direction on that.
Absolutely, and no, that's no comment there, right? We're all good with that, everybody?
Right.
Okay. Number 5, within 90 days after each wireless carrier installs its antennas, excuse me, the wireless carrier tenant on the tower shall submit an EME report to the town's building inspector to confirm that such installation complies with all FCC regulations regarding radio frequency emissions, together with actual EME readings at the base of the tower and the property line of the property. And that's in conformance with the bylaw. Right? So we're all good with that.
Yes.
Okay. Okay. Number 6, within 90 days after each wireless carrier installs its generator, the wireless carrier tenant on the tower shall submit a sound report that confirms that the generator does not exceed 62 dB at 7 meters, 21 feet. Yep, I'm fine with that. And everybody good with that?
Yes.
Okay. Number 7, the term of the special permit shall be for 10 years and shall be subject to further successive renewals from this board. So, that refers to one of the waivers. And as well as the RF report as well. We'll discuss those waivers after this. I forgot about those. So we'll discuss that after these order conditions. But what's the board feeling? I mean, Chairman of the Select Board, Ms. Benoit, brought up a good point at one of the meetings about, you know, I believe the bylaws, every 3 years, you have to reapply for this special permit.
Is it 3 years or 5 years?
It's
Yeah,
5?
I think it's 5, yeah.
Okay. What do you guys think?
I'm fine with 10. Didn't we discuss 10?
We did, and then they brought up, you know, hey, maybe, you know, we should make sure they're complying with everything. You know, if we're gonna give waivers to certain things, maybe we should at least,
I'm good with 10 based on, you know, useful life of equipment and everything else.
Chris, if I may.
Yeah.
I think that her comment stemmed from the board was originally not going to have them come back at all.
Yes.
Correct.
And then in response to her comment, the board said, how about 10 years?
okay.
That was where it
All right,
came
so we
from.
did agree to 10. Okay, thank you, Tamika. Thanks for keeping me in line. Rick, any question, any problem with the 10 years?
No, Chris, I'm fine.
Okay. All right, so if you guys go with that, I'm fine with that. We'll go with that. 8, the applicant shall post a renewal bond in the amount of $50,000, which amount shall be increased by 10% every 5 years. I'm fine with that. That's for the removal, I think we should add in here, for the removal of the tower. Okay?
Right.
So we just add that to that.
That's renewal bond, is that supposed to be removal?
And site remediation, Chris.
Yes,
Hold on.
I agree, David.
I'm sorry, what was that, David?
It's a typo in 8. It says renewal bond. Should
Okay.
be removal.
Removal. Oh, okay, yes. Thank you, okay. So change that to removal. Okay. Is that what you're saying?
No, and site remediation, you don't want just remove, take the tower down, and you got a big cement slab there. You want, you know, site
No, per our bylaws, they don't have to remove,
They don't have
they
to
can leave the site as is,
Okay.
cleared, you know, that's the bylaw. So we
Okay.
we talked about that, we weren't gonna require them to put the trees back or any
No,
vegetation,
it's-
you know, take out the road or whatever. Okay?
Including the base?
I'd have to look at the bylaws. Let's,
I have my glasses, but here I'm on the page.
okay.
Pages.
Mr. Chairman, can I just clarify
Yep,
something about?
Yep, please do, David, go right ahead.
Yeah, thanks. Condition 4, I just want to sort of double check. The language I have in that condition includes the qualification that it's, the height is a unique condition of the decision to preserve an aesthetic benefit to the town, and that any further extension of the tower requires an amendment to the special permit. I think that was intended to respond to our discussion about the federal law that allows towers to be extended pretty
Yes.
much by right.
That is
The
correct.
cap, and this is intended to put a cap on that.
Yes, that is the intent.
Yep.
Yeah.
Great,
6409.
thanks.
Would you mind just emailing that language to us, David, the way you said that?
No, I just read it from,
Oh,
it is the same- he read
my
my
copy of
language.
4.
Oh, okay, I'm sorry.
Yeah, I just want to make sure that it's in your copy of 4.
How's the bond here?
It is.
Okay, the bond, all right, so removal of antennas, mount, equipment shelters, and security barriers from the subject property. Proper disposal of waste materials, restoration of location of personal water sources, with natural condition, except that any landscaping and grading performed for the facility shall remain in place. Okay, yeah, so that concrete would have to come out. Yeah. To its natural condition.
Thank you.
So the fence, the concrete, everything has to come out.
Yeah. So, site remediation, basically. Yeah, you don't put new trees, you don't
Yep.
put new trees in, but,
And just put per the bylaw.
yeah.
I mean, it's pretty straightforward right there. Might cost you a little more than 50 grand to rip that concrete out of the ground. In all fairness, I mean, honestly, I'm not trying to,
Yeah.
you know, I mean, taking down the tower and whatnot and getting all that out of there, you know. Everybody removing their equipment and everything, that's 50K,
Yeah.
but
I
that
would s-
concrete thing there could,
I would say that the bond amount is substantially more than what Mr. Maxon felt was necessary, so. And it's more than my client originally anticipated.
the 50 or more than 50.
50, even 50 is substantially more than what.
David, do you think 50 is enough to pull that concrete and everything out of there?
Well, when you get into site remediation, it gets to be a big number.
Yeah.
Like, I don't know about 50, but what we were originally talking about was if you had to drop the tower and clear all the surface stuff out, and then cover over the foundation, that's a couple of tens of thousands of dollars. But yeah, I don't really know about having to pull that out that much concrete and fill it with clean fill.
I mean, it doesn't really say you have to, you just have to put it back to natural condition, so maybe you could cover over it.
Right.
Well, I don't think that's the way it was
Well, you
written.
just chip 4 feet off, right? 3
Yeah,
feet
and
off,
most-
and you just go over it.
Yeah, in most towns, you have to go 6 inches below grade. That's
Yeah.
what you have to, that's what you have to do.
Yep.
What's that?
How much is this pad?
The compound.
30 by
Sorry?
30?
30 feet deep? No,
Well,
not,
30 by 30 by about, I don't know.
How deep?
He said it, I had it written down somewhere, it's, those things are a monster. We've built those things, there's some 40 by 40 that go down 25, 30 feet deep, depending on the size of the tower.
that's solid 20-foot concrete.
Rebar and concrete,
Wow.
up to the wazoo.
So it's
You
not-
gotta pour it,
it's not-
you gotta pour it in sections
Oh,
and
yeah,
layers,
yeah,
and keep, boxing it and, hint down it. Yeah, it's massive. Well,
I'm pretty sure when we wrote that thing, I don't know if that was been rewritten, but originally when we wrote it, it was meaning pulling it all out.
yeah, I just don't know that it states that. What is your opinion, guys? Jacob, what do you think?
To natural condition.
Natural condition, I don't think, I mean, requiring them to rip the whole thing out.
I don't think that's.
I mean, isn't the 50,000 a little higher than average anyway?
It is.
Did we discuss?
Yeah.
A lot higher, actually.
A lot higher, yeah.
Yeah.
Mr. Maxon testified to that, but.
All right, we'll just leave that at that.
Yeah, yeah,
All right.
Hopefully it never has to come out.
Yeah, I'm
Right.
fine. Someday it will. Everything does. Okay, and then the other, that's number 8. That's not it. Just had that list here. Right, here we go. I had a couple other things. I guess we got the extension of the 20-foot tower. I like that language, so I'm fine with covering that. I was gonna add in subject to Conservation Commission, but they have that, so I don't think that's really an issue at this point. I don't think we have to include that. Let's keep things simple here. And then just the selective tree cutting, so just that, creating that verbiage to that,
To condition 2?
to condition 2.
Yep.
I think, so, you guys good with everything, everything else? Do we wanna go through the waivers real quick?
Yeah.
And, sound look good, the bond look good. Waivers. Attorney, I'll let you take the lead on the waivers that you're looking for.
I thought we had gone through the waivers, I apologize.
Well, we did, but some things have changed. I'd just like to recap them if you don't mind.
Sure.
Make sure we're all on the same page, and Attorney Morris or Surratt, whoever's writing this decision, can make sure we get all these. I'll probably have the two of them combine the notes, to be honest with you.
Yeah.
This is gonna take a double-edged sword.
Let me just get my notes.
I think we were good in all, like the first 1 through 10, 11, site plan requirements, locus map, all those things. We were fine with all those. I think they're meeting.
I believe we even voted on the waivers.
Yeah.
Did we?
Voted
No,
on
we did the variances. I don't think we did the waivers. I don't remember voting the waivers. The waiver for the RF.
Good on that.
Waiver of the requirement to measure the noise 90 days after commencement.
we
Yep,
addressed
so
that.
We've addressed that.
Right,
so I
so
don't-
we've addressed that.
So we won't really be granting that waiver, we'll just be granting it per the order of conditions.
Correct.
And the same thing with the RF, yeah.
Yeah.
So your waiver,
So we just X those out
yeah,
completely.
so those,
And then, yeah, the waivers on the variances, we ended up granting all 3.
yeah,
Just the 10-year issue, wasn't that a part of
That was a waiver,
Yeah.
that's right.
So we've
So we
Yeah.
decided to
addressed that.
limit it to 10 years.
there's that one. So in your application, I'm on page 27, right up in the 20s there, attorney. I think around, pretty much pages 20 to like 28 or something are the waivers, and you've got like the locust map identifying things like that, zoning district. All those things there, but I want to say, no, so those are just your comments to our zoning comments, that's all. The waivers, where the hell did the waivers start here? I think it's on page 25, if you're at. Waivers and bond, yeah, waivers, item number 8, waiver. The SPA may waive one or more of the application filing requirements of this section. To the extent the board believes that the provided information does not comply with the requirements, Blue Sky believes additional detail will not tend to provide substantial assistance to the board, so basically, if there's just anything in there, is that what number 8's saying? Did you guys? The SPGA may waive one or more of the application filing requirements of this section if it finds that such information is not needed for a thorough review of a proposed personal wireless service facility. You state Blue Sky has submitted detailed stamp project plans in support of its application prepared by Proterra Design Group, LLC, photo simulations and supporting materials. The plans and the other materials provide information on all aspects of the proposed facility installation. Due to the size and scope of the proposed installation, Blue Sky believes that the project plans submitted meet the requirements of the town of Rutland to the extent applicable to this proposal. To the extent the board believes that the provided information does not comply with the requirements, Blue Sky believes that the additional detail will not tend to provide substantial assistance to the board, and therefore Blue Sky respectfully requests a waiver from any such requirements as the information is not required to determine compliance with the standards for a variance and special permit. Whew. So, yeah, so I think that's just, I don't know that we have to grant that waiver. I mean, if we
I agree, I think you've approved the site plan.
approve the site plan, I just think that waiver, I don't feel comfortable
Yeah.
kind of just giving him carte blanche, like if we, if he didn't submit something, we can't come after him, like, well, if we
Yeah.
approve it, you forget about it.
Yeah,
It's
it
over.
was about a bit of a belt and suspenders approach. you know,
Absolutely.
And there were also requests for the site plans to be modified, which we did.
What you did,
At
and
the
all that
last
stuff,
hearing.
the additional information was
Correct.
given,
Right.
so I think at this
Just whack
point,
that one.
I think at this point, there's no
Right.
waiver there for number 8 there.
Yep.
Going to the next page. Blue Sky requests a waiver of the requirement provided by the RF, so, under section 60 of the bylaw, item A, the 90-day thing, we've addressed that in the order of conditions, so I don't think
That's right.
we don't need to vote on that.
I
And
agree.
the same thing as B, under that section is the sound.
That's right.
We've addressed that in the order of conditions, so I don't believe this board needs to, need to do those as well.
I agree.
And you just go on to, and then the other next waiver I see, the bond. We talked about the bond, we talked about restoring the wireless to the natural grading conditions. The applicant will require, on page 28, you've got here, the applicant will comply with the physical removal requirements of the bylaw. That's what we
Correct.
want you to do, we're in
Yep.
agreement, no waiver, nothing to vote on there.
Consistent with the
Yep.
bylaw. Yep.
If required by the board, Blue Sky shall post a bond amount necessary for the physical removal of the facility. You're gonna do that, we've talked about that, that's a done issue. And that's all I got for waivers, attorney. Do you have anything else?
I don't have any additional
We don't
waivers.
need any, we don't
I
need
don't
any.
believe there's any waivers.
There's no waivers because we've addressed them all through orders of conditions.
Yeah, maybe that's my recollection, is that we
Yeah,
talked
no,
about them.
we've
but
talked about them, they
we
came
need
in
to
different
vote
ways,
on
different times.
Correct.
But I think at this point, we've addressed them all. You guys, Rick, you all good with that? We're good with
I'm good, Chris.
head spinning? Me too. Okay, all right, so I guess, to talk about voting for this and.
Well, Chris, just to back up if I may.
Yeah, please.
You said you were gonna open it up for
Oh,
public
yeah,
discussion.
thank you, Paul, thank you. Yeah, so at this time, there's no more information to discuss. Board members? No more questions, attorney, no more things to submit? Anything from your consultants?
Not at this time. Mr. Tom Johnson is available in the event that there are
Okay, somebody has a
questions.
question. Mr. Maxon, do you have anything else you'd like to add?
No.
Okay, thank you. So at that point, let's just open up the public discussion. Any questions or comments from anybody in the public? I'll just start in here personal first, and then we'll go to the online folks. There's a couple gentlemen here. You guys have any comments, questions, anything you want to say about this? Your name and address.
Ted Williams, 35 Overlook.
Thank you.
The question I have, how far away is the tower from the town property?
It's 160, 65 feet, right around that. Hang
So
on
if we
one
put the
second.
road in, the road was supposed to go right on the bounds.
Where's that plan?
Yeah, it's affiliate C-1.
So when you look at the buffer, that 150-foot buffer is pretty much, it's about 5-10 feet from the lot. I think it's 165.
It's 168.
Per the
168. to the
168, because I think 165 is the
What
bylaw.
plan
center.
page?
C-1.
Mr. Williams, you wanna come and see the plan here? If you wanna approach and see the plan. Is that
Just take your word for it, you
Yeah.
know? I know what it's all about, been down there. looked at it.
150 is the minimum frontage.
Right, exactly. Or setback.
Or setback, yeah.
Right. Fall zone.
Well, you thank you. Yep. Okay. Yep.
Thank you.
Property line setback is 165, 110% of the, yes. So you submitted a 140-foot tower. Per your application on A1, tower property line setback 165 feet plus or minus, which is 110% height of the 136.4 foot with the lightning rod.
Right.
So, but now the thing's smaller, so you're actually
Exactly.
even less than that
That's
as
right.
far as your requirements would go, so,
Exactly right.
okay. Anything else?
What do you think about the bylaw, or should it be looked over again?
I actually have a list of recommendations to adjust some things in the bylaw regarding the cell tower. I do have those. As Mr. Max, and quite honestly, I have a few notes here, and I don't want to get into too many detail, Dick, but Mr. Maxon, who's been just an incredible service and help and guidance on this process, and his knowledge of cell towers and particularly bylaws, and I know he says he's not a lawyer, but boy, he's not far from one. He's just missing a degree, so I'd like to almost possibly engage him to review these, because even his comments were, these are antiquated bylaws, and I think we need to bring them up to speed. And listen, the town did a great job 20 years ago, but there's some things missing here, and there's some things are almost ridiculous to have, where it's just crazy too much, and then some things we're missing.
Yeah.
So.
Technology's changed.
It has too, technology and the requirements, like he said, it's not just cell phone, it's data. Things are evolving, and these bylaws have not done that. And I think the town engaging Mr. Maxon in reviewing these and then proposing something to the town vote would be something that we should consider.
I like the idea. Thank you.
You're welcome. Gentlemen, yes?
Yes, Keith, 12 Maple Ave. I'd like to make a proposal for an order of condition. As carriers are added to the pole, the public's not going to be aware, or will they be aware of the activity regarding emissions in the area. Sounds like contracts have to be made, and one carrier will be placed at a time. Eventually, you'll have full capacity, full RF emissions, but regarding some things that are happening in Pittsfield, where people are getting sick, the public, how is the public supposed to respond if it's potentially hazardous in simple ways, not the whole tumor, cancer threat.
Sure.
We're talking headaches, migraines, things that maybe people consider are problems or not problems. There's people that live with detrimental headaches and migraines, they have to take medicine for it. If it's, and through the chair to ask even David Maxim, if, if he's an expert, there can't be no health effects that ever occur with these. I'm sure technicians that work on these towers, they're the first and foremost, most exposed people. There's probably someone out there that's had to have a workman's comp issue, sued a tower over just the possibility of that exposure. So I'm not, I'd like to figure out how the public's supposed to deal with the onset of issues they've never occurred and happened in their life, and whether because of their relationship to this location and how this is all going to go.
To answer your first question about when another carrier comes on, this tower's approved for 4 carriers.
Yes.
Okay, and per our bylaw, I don't believe they don't have to come back to us.
No,
they
but-
do have to submit the testing
Yeah.
and the sound testing as we discussed. So after they hook that up, within 90 days, they have to go out and do their RF testing, and they have to submit that to the town building inspector
Yeah.
for his acceptance.
So,
Okay, as well as the sound for the generator. Okay.
and I could publicly ask the inspector dating on that. He would be able to release documents like that.
Oh, I'm sure that'll all be public
It's a matter of
information,
public
sir.
record.
You know, absolutely. You know, like under the Freedom of Information Act, you can request that anytime. Or
Yeah.
you know, it won't be a public hearing though. Okay,
Yeah,
they're
no
not going to come to us and
announcements.
say, "Hey, I want to put another antenna on this tower." That's not going to happen. They're not going to the planning
No, of
board.
course not.
There's no public hearing notification. They
Yeah.
can just do this, and you just have to be aware of when you see the additional antenna go up there, then you can request that information. Okay.
Yeah.
And just, if I may, we are requiring that they do not just a mathematical modeling
Yeah.
sampling, but to actually do a physical reading of the RF frequency after a reinstallation.
Are they expecting fluctuations? Do they want to hit 5%? Do they make more money at 5%?
No.
No,
Okay.
now all the stuff we went through,
Yeah.
even when this thing is fully maxed out, I don't know if you're here for the experts, we looked at all the numbers on it, and they were confirmed that the RF radiation, if you're within 6 feet of the router in your house, is about the same as the sweet spot in this, which would be about 1,000 feet away, 600 to 1,000 feet away from the antenna is where the highest RF radiation would be, is less than if you were 6 feet away from your router in your own house.
Is it per panel, per carrier? So they have like
No, that's the whole thing, all done.
every, yeah.
The RF frequency, and I did a lot of research on this, I
That's
have a
good.
master's degree in math, so,
Sure.
looked at all the numbers and the calculations and all this stuff. The RF frequency from your cell phone, your earbuds, and your Wi-Fi in the schools
Laptop.
is more than this thing, than you're gonna be exposed to on these towers. So,
Yeah.
But if you did have an issue, just to answer your question, if you did have an issue,
Yeah.
that would become, I know other communities, it's gone to their Board of Health, sir.
Yes.
Okay?
Right.
And that is the commission in every town that you would take an issue, environmental, any type of issue that you have.
And it would be
Okay.
considered a nuisance for that person if they've felt
Correct.
health
If it's a
effects.
zoning issue, you go to our building inspector,
Yeah.
and then he's the zoning enforcement officer, the Board of Health deals with the Board of Health issues. Okay?
Yep.
And always, as always, Mr. Kelleher that was here, he was the acting town administrator, and whoever takes his position in the future, or the select board. You know, you can call down to the office, get Ms. Murphy or one of the other secretaries, they'll get you on the agenda to speak to the select board, and they could guide you in the right direction if you ever felt there was an issue.
Okay. Yeah,
All
as
right.
long as you guys at least maybe hear a little bit of that,
Yeah.
whether it's on your minds or not, just so you know.
Okay.
Thank
Anything else, sir?
Maybe just to submit quick paperwork about something that is happening in Pittsfield to I don't know if it's important to the ZBA, but for record, for maybe the Board of Health. to
Yeah, I know
reference.
there's been some talk about that, and some information was submitted, I think, at the very first one.
Okay.
You're welcome to submit anything you'd like, sir.
Yeah.
Okay?
Thanks.
Just drop that out to Ms. Murphy.
Yep.
Okay, she'll make it a public document. At this point, let's go online. We got a hand up. David, I see David has his hand up. If you don't mind stating your name and address, sir?
Yes, it's David Gold, 4 Phillips Road. Can you hear me okay?
Yep.
Okay, great. So, two things. First, appreciate the work that you've done over the months, and there's been so much to try and process. Whether you like it or not, I'm an abutter, and generally people who are butters to a cell tower are uneasy, have a lot of concerns, and are waiting to find out the fallout after the fact, of having an installation like this near their home. But this is in the center of town and near a school. And so that affects a large quantity of the population, anyone who goes through town, anyone who's picking up their kids at school. And so there's a large, whether you like it or not, it's a contentious issue, and it affects the whole town. And so for that reason, extending a waiver for a 5-year special permit to 10 years, to me, doesn't make any sense at all, because there's still a lot of question marks. Yes, we had a balloon test at 140 feet. I know I'll be able to see it from my house, but it's not the same as when there's antennae sticking, bristling out from a very unattractive industrial, that's just the reality, tower. So to push it, to offer these waivers when there's really a lot of people ill at ease, and it's, I've been active and I've talked to a lot of people, and usually my first statement is, do you know about the cell tower going up at the school? And I would say about 20% of the people immediately say, I'm opposed. I didn't do it, I didn't act like the boogeyman or anything. I just said it straightforward. So yes, people are concerned. And 450 signatures is in response to the fact that there were only a dozen people at the meetings that were concerned at the ZBA meetings. That's just shows the seriousness of it. So I hope you take that into consideration when you're considering some of these waivers. And then for the record, the Telecom Act of 1996 gives the local governments the power to control the placements of cell towers. That's you guys, and that's a tough job. And Congress has decided that the town is the expert in terms of what they want the town to look like. And and it's also the applicant who bears the burden of showing that the proposed site is the only possible location to improve their service. And they have to somehow justify that this is going to be non-invasive, non-intrusive. And frankly, I don't think they've done it. And you've looked to David Maxim for a lot of guidance and advice, and like you, I've been impressed. But you've accepted a lot of his guidance in areas that are not really his expertise, but probably experientially, it definitely carries weight. But one thing you didn't accept was pointing out that there was more than one viable alternative site that could be looked into. And I don't quite, in fact, you discounted it because of AT&T's propagation maps, which do not serve as probative evidence. So, we come back to it, but I'm going on the record as saying that was what he was brought on to do. That is his area of expertise. and he found alternative sites, and that alone is enough to say, let's look into this, and if they are more in keeping with the bylaws and the spirit and the rural nature of the town, then why not go, work on that? But you discounted that, and I'm just saying that for the record. Thank you for your time. Listen.
Okay, David, thank you. I'm not in total agreement of all the factual items you stated there, but I do respect your opinion, sir. And I want to thank you personally for the hard work you've done on this. You've been very diligent in your effort here. You brought us Mr. Maxon, and perhaps the result, whether or not the result you get is the one you want, I do think you have made a big difference in this hearing on many items and many issues, and I just want to thank you. Next up is that Carolyn Streeter? Miss Carolyn Streeter?
Yes.
With her hand up?
Hi.
Yep, please state your name for the record. Go ahead.
Carolyn Streeter, 11 Meadowbrook Circle. Can you hear me?
Yes, go ahead, ma'am.
So, thank you for the opportunity to speak. I have a couple points and a couple questions. I do think it's very relevant in Karen Greenwood's one of her pieces of correspondence that was discussed at the start of the meeting, that Exhibit 5 in the application states that an alternative site was dismissed because it was too close to the nursery school, and that's AT&T's words, or forgive me if it's Blue Sky Tower's words. I believe that's AT&T's words. It's in the application. I think that's very relevant since a site was chosen that's 168 feet from the middle school property and 530 feet from the middle school building. And I do hope the zoning board looks into that and asks AT&T about that. A note on selective cutting. Per that definition, that means that mature trees can be cut in the no-cut zone. Is this what the zoning board, is this the intention?
We've discussed that. I mean, the selective cuttings, the tree's getting old and it's gonna die. Before it falls down and takes 5 other good trees with it, you remove the tree to save the rest of the forest, ma'am. That's what selective cutting, that's what we're referring to.
Well, per the definition that we heard tonight, mature trees, it's the cutting of mature trees, comma, or defective or of inferior kinds to encourage the growth of the remaining trees in a forest or wood. So mature, it includes the cutting of mature trees to encourage the growth of the remaining trees in a forest or wood. So it does include the cutting of mature trees in the no cutting zone.
Mr. Chairman, I can attempt
Please,
to
David, go
clarify
ahead. Yep, please.
Yeah, it is a technical term used by forestry people, and the whole purpose of selective cutting is to encourage the rest of the forest to remain healthy. And in some cases, cutting a mature tree is a proper forestry activity in order to encourage the rest of the forest to remain healthy. So there's no loophole here. It is all about maintaining the forest cover and the forest canopy when a forester uses selective cutting.
Thank you, Mr. Mattson. But the point here is to camouflage this tower. We're not the state forestry department. We're not trying to ensure that this woodlot is maintained sustainably. The reason the board asked the applicant to go back and consider these tree cutting details is because the board was concerned that there wouldn't be enough cover provided by the trees if they were cut for the cell tower. And here, selective cutting allows the cutting of mature trees in the 150-foot no-cut zone. I'm just pointing this out.
Okay, thank you. Yep. Keep in mind, the 150-foot buffer plus the other 50-foot buffer equals 4 times the amount of the bylaw buffer that's allowed. Per the bylaw, they only need a 50-foot buffer around that tower. Per our bylaw right now. We have required, and they have agreed to, 200 feet of buffer around the tower, plus the other land between those two buffers. I don't know what that footage is. So we are way beyond multiple times the amount required, Mr. Streeter, just so you know, okay? So yes, within that 5 to 10 times amount of requirement buffered, there will be selective cutting, yes, ma'am. Okay? That's what we've agreed to tonight. Anything else, ma'am?
Okay, yes, absolutely. Groundwater. You guys, please put yourselves in my shoes when I discuss this matter. Understand that I'm in a butter to 12 Phillips Road. I share a piece of this woodlot we're discussing on my land. It is absolutely by all means getting wetter, as Mr. LaBaffa recognized earlier tonight, as I have told the zoning board in previous hearings.
Ma'am, I just want to stop you right now. I understand your concern about about water on your property. You have to understand, if you have a water issue on your parcel of land, okay, that is an issue with the Conservation Commission. And the Conservation Commission will come out, and if someone is illegally or indirectly dumping their storm water directly onto your property with piping and collecting that water and dumping it onto your property, then you have the case to bring them up to the Conservation Commission. Okay, that is something you can do now. You could have done 3 years ago. You could have done it the day you saw this problem. If it's just a natural flow of groundwater, we can't. That is not an issue that this board has to deal with. Groundwater takes its path. Okay, ma'am. And the fact that this man owns 14 acres and and he's at a higher elevation, that water always flows down to the lower elevations. And that's all been done through the Conservation Commission, the roadway, the area he's clearing. He has the right to clear his land for whatever legal reasons he chooses to do so. He's here before us. He's not breaking any laws or anything like that. But he has to keep that water that falls on his property to flow back to where it normally would. Okay? So...
Can I explain some of my situation here to you, please?
Ma'am, I'm sorry. I think it's a Conservation Commission issue, and I really just cannot keep going on. We've talked about this multiple times in other meetings with you, and I don't know how to explain this to you anymore. I don't know what to say. Do you understand what I'm saying? Are you listening? That this board...
Water coming up through the floor drains in the...
Were you at the Conservation Commission last night to discuss this? Were you at any of their meetings?
I sent the zoning board an email earlier today.
Ma'am, that's not what I asked you. I asked you a question, Ms. Streeter. Were you at the Conservation Commission for this hearing last night?
I have COVID. I was extremely sick with COVID yesterday. I shouldn't even be here now. Listen, I brought this topic...
What else do you have? I don't want to discuss this groundwater issue with you anymore. What is your next issue that you would like to talk about?
I want to say that the 800-foot access road, the site development involved with that road is a major concern of mine, not just the tower compound itself. And I don't see how, if an abutter has a major groundwater issue, how that's not relevant to the site development of a 12 Phillips
Do you have anything to discuss other than groundwater? If not, I have to ask you to. I'm going to ask you to stop talking. I'm sorry.
Yes, I do have
Then
other
please
things
move
to
on.
discuss, but if the zoning board told me in November and subsequent times that I brought up the groundwater,
Yeah, we
that
discussed the
zoning board-
Conservation Commission, and these people needed to go through that multiple times in meetings.
Please let me finish my statement. If the zoning board told me that this was the inappropriate place to be discussing my groundwater issues and where to take those issues, I absolutely would have done it. I am now going to take these issues to the Conservation Commission because now I know that the zoning board doesn't want to hear this, and that's why
With all due
I need to
respect,
take
ma'am,
it.
I am not responsible for you knowing the law any more than any other citizen in this town. So I am not going to apologize, or I'm not going to make any. That's not my problem. You're a tax-paying town member. It's up to you to know the laws and what to do with things. If you have questions, you ask people in this town. How about you asking the question? I mean, good God. I mean, take some responsibility for yourself and the situation you've had that you're saying for multiple years. Is there anything else? I'm not discussing this issue anymore. I'm about to cut you off unless you have something else to say other than groundwater issue, ma'am.
When we're supposed to bring up issues related to site development, I consider that one very related to site development. Now, what I would like to say is that in my correspondence, I referred to the tower as a 120 to 140 foot tower because we all know at this point that federal law can allow a tower to go up 20 feet after it's built.
I mean, it's an order of condition that won't happen. They will not allow that to happen. Okay, it's an order of condition.
Well, it's federal law.
Okay.
So now,
We're not discussing that issue anymore. What else do you have, ma'am?
My point with the email that I sent the zoning board about the coverage maps is that I do want the board to remain cognizant of the fact that in November, when we were showed these coverage maps, the residents and the zoning board were very underwhelmed by the amount of coverage being provided. Now we're saying this is for cell coverage and for data, but AT&T's proposal was about cell coverage. If we want AT&T to pitch better data to the town, why don't we ask them to do that instead of doing it in their stead? The cell coverage, the basic point remains, this expanded coverage, cell coverage is very minimal and the residents don't see the point of this.
Okay, well, we addressed that, and I have no further comment on that. We've addressed that. That's been done in the past. I'm sorry.
And I would just reiterate, to go back to Exhibit 5, look at that, why was an alternative site dismissed, as Karen Greenwood stated, as the application states, because it's too close to a nursery school, and then a site was
Duly
chosen.
noted. Thank you, ma'am.
Next.
All right, next up on the
Yeah, thank you.
online. Anybody else online that want to speak? Okay, hearing none at this time, I'll accept a motion to close the public discussion.
I'll make a motion to close the public
Okay,
discussion.
do I have a second?
Second.
Okay. Any discussion regarding closing the public discussion session?
No.
Hearing none, all in favor of closing the public discussion? Aye?
Aye.
Any nays? Any abstains?
Aye.
One abstain, okay, so the motion carries unanimously with one abstain. Okay, so at this point,
Make a motion to accept the site plan approval with the conditions noted.
Can I just want to be clear.
yep,
Were you just closing the public discussion or are we closing the public hearing altogether? Because those are two very different things.
the public discussion.
Okay, so if you're gonna make a motion on actually approving it, we have to close the public hearing first.
Close the public hearing as well.
Yes.
Make a motion to close the hearing. Public
Okay.
hearing. Second.
Bob, seconded. Any discussion to close the public hearing? Hearing none. All in favor to close this session of the public hearing?
Aye.
Aye. Any nays? Hearing none. Any abstains?
Aye.
Okay, motion carries unanimously with one abstain. Okay, thank you, Tamika.
No
Make a
problem.
motion
Sorry
then
to
to,
interrupt.
No, anytime.
okay, make a motion to accept the site plan with noted
Order of conditions?
order of conditions.
Okay, it's seconded. All right.
Can I just correct that to
Yep.
special permit?
Oh, yeah. Yep.
Yeah.
Special permit, yep.
Sorry.
Not site plan, correct. Okay, so. Yep. All right, and it's been seconded. Any discussion? Okay, the only thing, again, with the order of conditions, and Jake, do you feel you got a good grasp on all these? And will we send these out for review?
We can do a draft.
Do a draft, and can we review these online, Tamika?
How
does that work?
What do you mean review them online?
Well, like, Jake's gonna create a draft of all the orders of conditions. Rick, you're working on the decision, the rest of the decision, is that correct?
Yeah,
Just so I know, just so we get this framework there.
It could be a cumulative
we
effort.
could, Jake, are you proposing that Jake and I draft, the decision?
Well, I know you said Jake's been keeping track of the order of conditions, so I just want to confirm here who is doing exactly what and how this is all gonna play together, and how we, tweak this if there's any comments we wanna make to those order of conditions, to the verbiage.
So
All
I
right.
could, I could come
Well,
up with a
Chris-
draft, I could send it out
Okay.
for comment, and then when I have a final draft, it'll be made part of Rick's final draft decision.
Okay. Rick,
Yeah,
what's your
I
thoughts?
I can work in conjunction with Jake on that,
Okay.
and we'll work together, and
All right,
there's,
and Tamika.
I don't think there's anything inappropriate about sending drafts, circulating drafts by email.
No, so
I think that's acceptable. Tamika, am I wrong, Tamika?
no, so the only thing I would say is that if you have a comment about something you want to change, I would respond only to Rick and Jake.
Okay.
And then if that way, there's no violation of open meeting law.
Yep.
And then when they send out the, that final copy with all the revisions, that way other members can see,
Okay.
oh, hey, this changed or this changed.
And then we have to send it to the attorney.
So we have 14 days from today to get this clocked in with the town clerk.
Okay.
So within that
Okay,
time frame.
Tamika, can I interrupt?
Yes, of course.
I think it's not a variance, it's a special permit. It's 90 days from the close of the public hearing. 90 days. We don't, I don't think the 14-day applies. Am I wrong on that?
Well, it's 21 on a variance,
It's
so
90
20.
days, it's 90 days until a decision has to be made, but once the decision is made, we have 14 days to clock it in.
All right, I'm gonna have to, I
You
don't
can
think so.
double check
I
it.
think it's 90 days. I don't
You can
think it's
double check the
14 days. Yeah, it's not the bylaw, it's chapter 40A.
Okay.
And I think I incorporated that into the rules. Would you double check that for me though?
Yeah, we can, yes,
I
I think Attorney Seuss is actually pulling up the.
Trying to, yeah.
He's gonna try to pull it up right now and,
sure. But yeah, once we have that, we can certainly circulate that
Sure.
to Attorney Sousa to
yeah,
take a
and
look
get,
over and,
just to get
yeah,
his review
absolutely.
and
Yep.
make sure that,
Mhm.
that it's amenable.
Yep, and we can do all that before I put the electronic signatures on.
Just
there.
like we did the HPD thing.
Right.
We had attorney,
Yep.
and Dave George,
Mhm.
their attorney, Dave George, worked through the final verbiage of everything to meet the intent that we voted upon.
Yep.
So Rick and I can only communicate with each other?
No, so once, my recommendation is that if you guys work with each other, you come up with a draft decision.
Which we've done
and you
before.
email it to everybody.
People comment.
Yes. We just have to be careful of how much discussion is going back and forth amongst all of the members of the board in one email chain, because that could be a violation of open
A
meeting.
violation, my understanding of the open meeting law would not be refining language that we voted on. It would be.
Oh, that's all
For
we're doing.
It would be
discussion.
creating new language.
No. Yeah.
Right.
Which is not what we're doing, but if he says something,
make a
and
typo.
we
Further
respond,
discussion.
he said, I respond to it and say, hey, that's not the right word to use, I think this more encompassed what we were meaning, and then Chris chimed in, and,
As we just did on
chimed
the
in and said,
HPD.
yeah, you're right, that's the
It's
better
to
word.
this intent that we
I
discussed, and we voted on this intent. That language will be verified.
That's not a
approved by both
violation of
sides.
open meeting. Violation of open meeting law would say, hey, let's add this other
Exactly,
thing.
if you're
So that
discussing it
would not
further
be-
or
yeah.
changing anything.
So we
Changing the
can
intent.
reply all as
So
long
maybe-
as we're not adding.
Maybe we should just amend this motion to include the order of conditions will be amended to the intent that we have voted upon and agreed upon tonight as a
That's the way it
board.
always is.
Yeah.
Order of conditions as discussed at hearing.
Yes,
That's-
thank
yeah,
you.
that's what
Chris?
you're
There you go. Yes, Rick?
Hey, Chris, just a housekeeping measure.
Yep, please.
You've got some interested persons that keep sending chats, and you close public discussion. So would you please tell this individual to stop chatting, because
Shut
we're
the
not-
chat
we're
off,
not-
Tamika.
we're not
I
gonna take
can't,
up
that's
his.
back there, we
action.
can't see it on our end
Okay,
anyways.
Peter
Yes, I
Crane,
can see it.
yeah,
Yeah.
okay, I can't see any chats, I don't know. I don't know.
Okay, well, if I'm the only one who can see it, okay. Okay, fine.
Well, anybody could,
Yeah, I
if
think
you
folks
clicked
on
on the
Zoom
chat
will.
button, it would show
Oh,
up.
those on Zoom,
But
they
we
see the
can't see
pop-ups,
it
yeah.
because we don't see
Okay.
that part.
All right, so,
And this individual is telling us what to do.
okay, so I'm gonna ask that whoever's online, stop publicly commenting on Zoom, please. And anything commented after we close this would be just null and void
Right.
of public comment,
Can't
not
accept
accepted,
any more
should not be something that we keep in our decisions or part of our discussions and things. And if Peter Crane, if you can hear me, or whoever's back there, please just shut that chat room right down, please. Thank you. Thanks, Rick. Thank you.
All right, now, Chris, one more thing.
Please.
So Jake asked for a clarification, and I'm glad he did. All right, so my understanding is that we're gonna, Jake and I are gonna put something together. We're gonna send it out, and Tamika, and I think rightfully so, is suggesting that we don't reply, the people who have comments don't reply all. They simply reply to Jake and myself.
Okay.
That way we don't have
A public
violation
discussion.
of open meeting law.
Gotcha.
Is that what you were saying, Tamika?
Yes, that's what I was saying. Paul feels that if it's not changing the language, that it would not be a violation of open meeting law. So it's really at the board's discretion, how you guys.
I think we should just reply to just the person that sends it. If anybody has an issue, let's just be on the cautious side here. I think everybody can agree on that.
Yeah, and
Let's
even
not-
then, it's only gonna be to refine,
Yeah,
something
Yeah.
that we've
Yeah.
already discussed.
so, yep.
Okay.
And again, for that same intent, Paul, we're just tweaking verbiage, but let's just keep it to that single person to tweak the verbiage and,
Yes.
all right?
Sure.
So, okay, so, boy, did we get all that?
I think we did. I think the only thing we have to clarify is 40A, just to see what that time frame is.
Okay.
You will find it, Attorney Sousa.
I believe
Tamika,
it's,
do you have the rules in front of you?
I believe it's 14 days.
14 days,
Yeah,
Rick.
after if you vote,
So
then it's
vote
within
it.
14 days.
Do you see a problem with 14 days, Rick?
Um,
48, section
I mean,
9.
all right, I mean, I just want to ask Attorney Sousa, so
Go ahead.
where are you citing from, Attorney Sousa? Are you citing from 40A?
48, section 9, regarding special permits.
40A, section 9.
So if you vote.
All right, well, yeah, I mean, for purposes of getting this hearing done, let's go with the 14 days. Just for my own knowledge, I don't have it in front of me, I'll take a look at it,
Okay.
but I'll take your word for it. We're not gonna drag this out anyways, we are gonna get this done, probably.
Let's really try to shoot for the 14 days
Yeah,
here. And unless there's a serious reason, if you're gonna be away, or there's an issue,
How about 4 days?
yeah, 4 days, is more like, yeah, Jacob.
So, just to that point, Tamika, can you please let the public know what their ability is for appeal and all that after the 14 days? Is there a process?
Yes, but that's not through the town. That's actually done through the court. So there's nothing to be done on the town side. They would have
Okay,
to go
for
through
the
the court
special permit.
system.
Okay, so anybody's out there can put an appeal into the land courts and
And or Superior Court.
and/or Superior Court and follow up there
Within 20 days, within
Within-
20 calendar days.
within 20 calendar days.
Talking of the
And
decision.
again, that didn't happen with the variances,
That's
but
correct.
people, you have the right and ability to do that.
Yep.
All right, just one only last thing I'd just like to state. Member Rick Surratt, this will be his last meeting as a ZBA member. Yes, Attorney. I'm
I
sorry.
apologize.
No, please do, please do. Go ahead.
I don't want to interrupt your
That's all right.
accommodation of Mr. Surratt, but I don't believe the board voted yet for the special permit.
Okay.
No,
we
they did.
You did?
Oh, I
No,
apologize.
they did
They
not.
did a first and a second, but you didn't vote.
Oh,
That's
We
right.
didn't vote.
Yes.
Okay, I was just, while everybody's still here, I was just gonna discuss this. Can I
Thank
not
you,
discuss?
Attorney Sousa,
Can I
yes.
not talk about that right now until we vote?
Let's vote on the decision
Okay.
and then you can
All right.
transition.
All right, so hearing any more discussion on the approval of the special permit for the cell tower as amended with the order of conditions, as amended as discussed, is there any other discussion?
We've already had a motion to vote on
Okay.
it, so it's just.
So now, all in favor? Aye. Please raise your hands. Thank you, okay. Any nays? Any abstains?
You're not a voting member.
So it is a unanimous,
That's why I have to abstain.
unanimous decision with one abstain.
Now there's no
No,
abstention.
because he's
There's
not a
no
voting
abstention.
No,
member.
okay,
so-
okay, thank you.
I'd like to raise
So it's
Thank you, Mr.
unanimous.
Chairman.
All right, so we'll work up this language, attorney, get it to you, and we can finalize that, everything there. Get that decision clocked in. Tamika will let you know when it's clocked in.
Very good.
Yeah.
Thank you, Mr. Chairman. Thank you, members
Thank
of the
you.
board. I know this is a lot of hard work, and it's very appreciative.
Thank
We're
you.
very appreciative of that. And I do want to hear your accommodation,
Yeah, I just wanted to say,
Thank you to Mr.
Rick
Surratt.
Surratt's online, he was the former chairman, he dished this chair position off to me a few months ago, and boy, he's a wise man, because it's been a hot 3 months, Rick. You old crafty dog, I learned a lot from him. I hope I can maybe serve the next man the same good deed, but, I just want to say, Rick's become a great friend of mine over the 20 years, and we've had a lot of fun, I've learned a lot from him as well. And as ZBA members, we're just volunteer guys here. And Rick's been doing this for 20 years, and he's been the chairman for 20 years. And I can tell you, over the last 3 months, the amount of hours, additional hours I've been putting into this position, God bless him for 20, because I don't know if I got another 20 years in me. Because he's just done a fantastic job. And you know, he's gone about it as such a quiet guy.
Yeah.
Never ever bragged about it, never ever says, look at me. You know, I mean, how many people, think about this town, and Dick, you're still here. How many people have done something for 20 years, volunteered?
Wow.
I mean, other than yourself and a couple other guys in town, I don't know who's got that kind of track record. So that's pretty rare. That's up in the stratosphere, and of guys who have given their time and energy to this town in doing the best that he can and the best that he feels is for this town. So I just want to thank him for that as a citizen, but as a friend, man, I've loved working with you. Thank you very much for everything.
Thank you very much.
And so at that point,
Night.
see you there. Do we have a motion to, any new other business or anything else to discuss tonight, please? No? All right. Thank the Lord. Do we have a motion to close this meeting tonight?
So moved.
Second.
Second.
Any discussion? Hearing none, all in favor? Aye. Any nays? Hearing none. Motion's unanimous. Thank you all.
Right.